Good afternoon. The Appellate Division First Department is now in session. Welcome to our virtual oral argument session for February 2nd, 2021. I am going to call the calendar now. So please respond if you're here, and we'll just confirm the time that you've been given for oral argument. The first case on the calendar is People versus McLean. That is submitted. Navone versus Zaxxon, submitted. SFT Children, submitted. Cayuga Nation versus Showtime Networks.
Lee Alcott. Yes, Lee Alcott, Barclay Damon for appellants.
Okay, you have 6 minutes and 2 for rebuttal. And the respondent?
Elizabeth McNamara, Davis Wright Tremaine for respondents.
Okay, and you have 6 minutes also. Thank you.
Thank you, Your Honor.
The next case is Trumbull Equities versus Mount Hawley Insurance.
Max Gershwire from Kennedy's for plaintiffs appellants.
Okay, you have 6 minutes and 2 for rebuttal. And respondent?
Timothy Delahunt for respondent.
Great, and you have 6 minutes for argument. The next case is Clean Realty versus City of New York. That is submitted. People versus Fernandez. That is submitted. Holston versus New York City Housing Authority. Submitted. Rosafort versus Bronx Lebanon Hospital. The appellant?
W. Charles Robinson for the appellant, Your Honor.
Okay, you have 5 minutes and 2 for rebuttal. There were 2 respondents.
Duchamp for the hospital, Your Honor.
You're for Lebanon Hospital. Okay, you have 4 minutes. Right. And Jewish Home Care?
Bob Vizza for Jewish Home. 3 minutes, please.
Okay, great. You've got that. The next 2 cases are Bankers Conseco versus Wilmington Trust and Bankers Conseco versus Egan Jones. Now, I know there's different law firms appearing for the defendants. I think I may have given a little too much time since the underlying issues are the same, although the legal issues are different. So who's here on Bankers Conseco versus Wilmington Trust?
Joseph Buckley for the plaintiff appellants, Your Honor.
Okay, I gave you 8 minutes and 2 in rebuttal. And what about the respondent?
Spencer Derland of Hodgson Russ for Wilmington Trust, Your Honor.
Okay, all right, I'll give you 8 minutes. I think that might be a little much. What about the second case? Who's arguing for the appellant in the second case?
Good afternoon, Your Honor. Richard Epstein, and I am representing the plaintiff's appellants in the Egan Jones case.
Okay. So we may try to cut that time down a little bit because some of the facts overlap. And what about the respondent on that case?
Thomas Leghorn for the respondent, Egan Jones, Your Honor.
Okay, very good. So we'll see how that goes. People versus Bruno is submitted. Rosario versus State of New York, appellant.
Good afternoon, Your Honor. Amelia Green for appellant.
Okay, you have 6 minutes and 2 for rebuttal. And the respondent?
Caroline Olson for the State of New York.
Okay, and you have 6 minutes also.
Thank you, Your Honor.
You're welcome. The next case is Pons versus Adrenas Partners. Appellant Pons.
Ken Sussman from McCapfell & Cohen for.
Oh, you don't have to tell us the whole firm. Just, you know, we know that. 5 minutes and 1 for rebuttal. And respondent Nunnerly.
Good afternoon, Your Honor. Alan Efron for respondent Nunnerly.
Okay, and you have 5 minutes. Next case, you're welcome. P62 LLC versus WFP Retail. The appellant, please.
Good afternoon, Your Honor. Kenneth Philbin for appellant WFP Retail.
Okay. All right, so you have 6 minutes and 2 for rebuttal, and the respondent.
Good afternoon, Your Honor. Mark Alonso. I have 6 minutes, and I'll try to go fast.
Okay. All right, thank you. The next case is Jaffa versus City of New York. Appellant.
Mikhail Schenker for appellant, Jack Jeff and Associates.
You don't have to tell us the name. We know who that is. I just want to make sure you're here, really. You have 5 minutes, and the respondent, you also have 5 minutes. Are you here?
Yes, Your Honor. Amy McCampbell for the City of New York.
Terrific.
Your Honor, may I ask for 1 minute for rebuttal?
No, you guys asked late. You each have 5 minutes.
Okay.
Campbell versus St. Barnabas. All right, I'll tell you what, I'll give you 4 and 1.
Yes.
Campbell versus St. Barnabas Hospital, the appellant.
Good afternoon, Your Honor. William Buckley for St. Barnabas.
Okay, you have 6 minutes and 2 for rebuttal, and
Thank
the
you.
respondent. Mr. Tordo, you are muted. But I see you, so I assume you'll figure out how, okay.
I
All
got
right,
it.
so-
No, sorry. Good afternoon, Your Honor. Sorry.
All right, you have 6 minutes for respondent. The next case is Nistenberg versus Standard International. The appellant JES Plumbing.
Good afternoon, Your Honor. Corinne Scotty for the appellant.
Okay, you have 5 minutes and 2 for rebuttal, and respondent Pavarini McGovern.
Good afternoon, Your Honor. Laurel Wettinger for the respondent.
Okay, and you have 5 minutes. And the last case on the calendar is Deutsche Bank versus Willock, and that case is submitted. The only thing I'd like to remind you, I know everybody, first of all, I'm glad everybody's here. And everybody, if you could please keep your microphones muted until we get to your case. When we get to your case, try to remember to unmute your microphones. We've all been on this, and we know we sometimes mute and unmute at the wrong times, but we will all try, of course. And please remember when you're arguing that it's hard enough doing it this way, so try not to talk over the judges or anybody else if at all possible. And it's worked very well so far. I have no reason to think it won't be that way today also. So the first case for argument today is, of course I lost that page. The first is Cayuga Nation versus Showtime Networks.
Thank you. Good afternoon, Your Honor.
Good afternoon.
May it please the court, Lee Alcott for appellants. I would like to begin with Plaintiff Halftown's claim. I agree that the test here is supplied by the Springer case, being whether a viewer of the episode, knowing the real person, would have no difficulty linking the two. And here we say, Your Honor, that respectfully, Supreme Court simply got it wrong, because the of and concerning test under Springer is satisfied. The similarities here are so numerous, they are so unique, and they are so specific. We have the same ethnicity, we have the same tribe, Cayuga. There's even a Cayuga Nation banner on the wall. The same status within the tribe, a council member. And then on top of all of this, the same surname, Halftown. And these are all very,
Excuse me, this is Justice Weber. Do we have the same gender?
No, we do not have the same gender.
Also, one of the main, I guess, plot points was that this individual negotiated real estate deals, was involved in negotiating real estate deals and also in electoral issues. Is the real or the individual, your client, is that individual also involved in negotiating real estate deals or electoral issues?
No, they are not involved in that, and we contend, Your Honor, that that is a particularly important point, that it alludes to the fact that they're involved in an illicit land deal, a deal
I'm
for...
sorry, somebody's mic is open. Please mute your microphones.
I'll wait, Your Honor.
Okay, go ahead, Ms.
Okay.
I'm sorry,
Yes.
go ahead.
I'm sorry, Your Honor. That is one of our points, Your Honor, that our clients, the nation and Mr. Halftown, were not involved in an illicit land deal. We're not involved in a mobile voting program. But a viewer of the episode might rightly infer that they were involved in such things. And those things, at least to the extent they're involved in illicit casino.
Well, your argument is that an individual would be able to necessarily know that this was your client. So you mentioned certain similarities in terms of being members of the nation of Cayuga, right? And
Yes.
similarities in terms of the last name. How else would someone know that this would be the same individual?
We think those are sufficient identifiers, and we think simply changing the sex, that's merely sleight of hand.
Counsel,
Question.
Counsel, I'm sorry, this is Judge Owen.
Yes,
This is Judge Owen. How does the disclaimer at the end affect your argument?
We
I mean,
contend
at the end, it says, I see it all the time when I'm watching movies, or really good movies. They have the disclaimer saying anything that resembles reality is totally disclaimed. It's not. This is all fictional. So how does that affect all your arguments?
Understood, Your Honor. We contend it's of no moment. And in fact, both of the cases cited by the defendant respondents, the Lyons case and the Dower case, and no case that we're aware of, Your Honor, specifically holds that the insertion of that disclaimer, which is basically gratuitous, self-serving disclaimer, they're identical.
But then on the flip side, wouldn't you then argue, couldn't there be an argument, a valid argument, that if we were to agree with you and say that that disclaimer is just really of no moment, then we'd be opening up the floodgates to so many lawsuits where people are going to say, that's me, and next thing you know, the disclaimer becomes, I mean, then at what point are we going to say that disclaimers are going to be meaningful? I mean, does it have to be right in front before they run the credits, right when they show the movies, whenever we get back to seeing movies, that they're going to have it right up front where it says disclaimer in big red letter? I mean, because what you're arguing is saying these disclaimers are of no moment. We shouldn't be giving them any credence. I'm not so sure I agree with that. That's kind of dangerous, don't you think?
I understand, Your Honor. I would simply point out the fact that if the disclaimer is to be given the effect that the defendant respondents would like it to have here, one could write anything. One could write anything, defame someone back and forth, and then just put a disclaimer on it. And furthermore, the disclaimer here, any similarities are purely coincidental. Is it coincidental that they identify the Cayuga Nation Halftown council member? That cannot be a coincidence, Your Honor.
Well, counsel, what did we do? You talk about deprivation. What about the fact that we're dealing with entertainment? I mean, isn't it clear that this is purely for entertainment? And then the other thing is, what do we do about all the cases dealing with law and order? What about those cases?
Your Honor, in this case, again, it is very specific and very unique. Every case is individual, and I recognize it's a high bar to get over. Okay, it's a very high bar to get over. But the test, again, and I didn't make the test, Your Honor, the test is set forth in the Court of Appeals in the Springer case. Would you be able to link the two?
So closely akin, closely akin that a viewer would have no difficulty in linking the two.
That's correct.
And so again, you talked about gender, you talked about being in the Cayuga Nation. However, the main thrust of this, the main issue is, again, the duties, the negotiating, the real estate, and the electoral process.
Understood, Your Honor. And in that case, in that situation, there are some distinguishing factors, but we're not required to show that the portrayal is completely indistinguishable. The Felter case states it more specifically. It is sufficient if those who knew the plaintiff can make out that he is the person meant. And if anybody knew Mr. Halftown, they would know that he is the person meant by this depiction of a Halftown Cayuga character. And the Felter case cites an older case from the Court of Appeals, the Corrigan case, that says the question is not so much who was aimed at as who was hit. And we say here the plaintiff Halftown was hit, and he was hit squarely. So we believe the similarities are sufficient, Your Honor.
All right. Thank you, Mr. Alcott. We'll have 2 minutes on rebuttal. May I hear from Ms. McNamara? Is that you?
Yes, Your Honor. Yes, Your Honor. Thank you very much, and good afternoon, Your Honors. Judge Weber, I think you hit the nail on the head, and that is the problem with this claim. The plaintiff has failed to meet the weighty burden of establishing a libel in fiction case, where the two components of unconcerning and factual depiction are merged, and the plaintiff needs to establish not simply that he might be identified, but also must establish that the facts plausibly depict the plaintiff. And it is really on the latter point, we would submit both, but it's really on the latter point that this claim utterly fails for the reasons that have already been identified.
This is Judge Mazzarelli. Aren't the differences between Mr. Halftown and Ms. Halftown really very subtle here?
No, Your Honor, not as far as the events depicted. This episode concerned a land deal in Kingsford, New York, which ultimately involved a casino. And it involved a voter registration drive focused on disenfranchised Native Americans that was being proponent by the chief character in Billions, in admittedly a fictional episode. But in the facts show, and it's not disputed here, there is no Kingsford, New York. So that's a fictional. There's no casino in Kingsford. There was no voter registration.
There is a Cayuga casino, though, isn't there?
No, Your Honor, there is not a Cayuga casino, I think, akin to what is described very rudimentary.
There's a Kingston, New York, is there not?
Yes, but it has no relation to this. It's a Kingsford.
But the point of it is, how would someone really know that? I mean, it's so close. The name Halfton, we have an individual who is actually named Halfton, who is a part of the Cayuga Nation, who I assume from the facts has something to do in terms of the business of the Cayuga Nation. Is that correct?
Your Honor, that was not pled at all. That's not part of the complaint. That is not part of the record, that he had anything to do with any land deal or any business involving casinos. Instead, he really argues the opposite. And I think in order to resolve this matter, it's important to perhaps compare the Springer case, which is the leading case in New York, and the Batra versus the NBC case, which I think if you run those two comparisons, the result is inevitable.
So I'm assuming that your argument is that the disclaimer is sufficient.
No, Your Honor, I don't think we're not arguing merely on the disclaimer. I think that reinforces the conclusion. But what drives the analysis in libel and fiction cases is that there needs to be a plausible nexus between the events depicted and the actual plaintiff and that plaintiff's role in those events. And that's where this claim fails. Let me focus for a moment on Springer. There, the novel was written by an ex-boyfriend. Her first name was used. She lived on the same street. She had numerous attributes that were very similar to the plaintiff. She was identified as the character in the novel. There was no question about identification, but because the events that led to the defamatory import bore no relation to her, i.e. that she lived in a penthouse and that she was a high-class prostitute, this court found that it was not plausible to find that she was actually depicted.
Well, how do you, excuse me, Ms. Mack.
Superficial similarities, is that correct?
Well, I think that they are superficial when it really comes down to that it's his last name and he's a member of the Cayuga Nation and had the same role.
Ms. McNamara, can I ask you a question? How do you distinguish the facts from the Springer case from the Court of Appeals and from the Batra case, which I know is a Supreme Court case, and that did survive the motion to dismiss, where the court was explaining all the different various factors. So what are the factors that you think distinguish one of those cases from another? Because I know these libel and fiction cases are you're treading a very, difficult line, so to speak.
Your Honor, that's
analysis.
Yes, that's an excellent question. And the through line and the distinction between Springer and Batra is that in Batra, the plaintiff was involved in the underlying facts that are being fictionalized and depicted. In Batra, the episode of Law and Order, which notoriously is ripped from the headlines, was involving a Brooklyn judge who had been accused of corruption. Mr. Batra, Ravi Batra, was inextricably entwined in that scandal, so that when the episode included an Indian American named Ravi Patel, who was also a lawyer, the court found that it was plausible that the events being depicted were fact. Here, however, in Springer, the events being depicted, the plaintiff does not allege that he had anything to do with any of the events. They are entirely fictional events with entirely fictional characters that were not inspired by real life. Invariably, when you look at the case law, if you look at Allen versus Gordon out of this court, you look at the Lyons versus New American Library, the distinguishing factor is that the facts, there is some underlying involvement by the plaintiff with the facts being depicted. When the plaintiff does not have an underlying involvement in the facts being depicted, the cases are invariably dismissed, particularly when they do have disclaimers like this one.
Okay, does anybody else have any further questions from the bench? All right, thank you very much, Ms. McNamara. I think we got your point. Mr. Alcott, you have 2 minutes on rebuttal.
Yes, Your Honor, thank you. I would like to make 2 points. The first is with respect to what is pled in this case. The record at pages 23 and 24, which are 2 pages of the complaint, specifically plead that Mr. Halftown is a member of the nation's governing body, the Cayuga Nation Council. So and he's also the federal representative. So for all intents and purposes, he stands in the shoes of the Jane Halftown character, acting on behalf of the nation in negotiations with governmental entities. The second point with respect to the casino is a rather more subtle point in that the nation does maintain a Class 2 electronic gaming facility on its reservation in upstate New York. So we believe, to the extent that that is an issue, we believe that we have pled that sufficiently.
Are there any allegation, or is there anything in the that there has been any cases or prosecutions concerning any irregularities in terms of any real estate deals or any voting issues?
No, Your Honor, there have been no such allegations.
So that would be purely fiction, is that correct?
To the extent that is depicted, it would be, but to someone unfamiliar with the Cayuga Nation and seeing the Halftown character, they could assume that it was true. The other point we would make, Your Honor, is this case was filed in 2019, a time of long overdue, greatly heightened sensitivity to cultural and racial stereotypes and bias. And as the Mencher case we cite says, whether language has the tendency to expose one to ridicule depends upon other factors such as the temper of the times, the current of contemporary public opinion, with the result that words harmless in one age in one community may be highly damaging to reputation at another time and place. This depiction of Native Americans may have been considered harmless in one age, but it is certainly not the current of contemporary public opinion, and it is this higher standard of contemporary public opinion to which the defendants must be held. We ask that the order be reversed.
Thank you, Mr. Alcott and Ms. McNamara, very much. Appreciate the arguments today.
Thank you, Your Honor.
The next case for oral argument is Trumbull Equities versus Mount Hawley Insurance. We have Mr. Gershwire.
Gershwire, yes, Your Honor.
Sorry. Okay, you may begin.
Good afternoon. May it please the court. This appeal involves 2 discrete issues. The first involves whether defendant Mount Hawley's recovery of $35,000 in so-called deductible payments, which we describe as self-insured retention or SIR payments, from its named insured Vordonia, replenished the policy's indemnity limit, thus making that amount available for Castle Point to recover. Resolution of that issue turns on whether those recoveries applied to the amounts that Mount Hawley paid to defend Vordonia in the underlying actions, or the amounts it paid to settle those actions. As Mount Hawley fails to dispute, the policy states that the SIR applies to both defense and indemnity payments, but is silent as to how the SIR is to be allocated between the two, whereas here the combined payments exceed the SIR amount. As the case law cited in our brief confirms, that silence equals ambiguity, which triggers the rule.
But the thing is, counsel, can I ask you something? There really is, in this particular policy that we're talking about, there is no self-insured retention. It's really a deductible. I mean, it was that was how the amount was determined. It didn't use the term self-insured retention.
You're correct, Your Honor. It uses the term deductible. We use the term self-insured retention because it's not the verbiage that the insurer chooses to use that matters, at least substantively. What matters is whether the primary distinction between the two is that a deductible reduces the amount that the insurer is required to pay, whereas a self-insured retention is simply the amount the insured must pay before the insurer must pay the full amount. And so what we're saying here is based on the actual language of the policy, what the policy describes as a deductible is more accurately a self-insured retention because of the fact that the policy states that that Mount Holly's obligation to pay under the policy, which is the $1 million limit, is excess. That's the words that it uses, is excess of the amount that it calls the deductible. So therefore, whatever it's the first $5,000, however you want to call it, whether you call it a deductible or self-insured retention, the bottom line is the policy language makes clear that the insured is responsible for the first $5,000 and the insurer is responsible for the remaining $1 million.
So that's 30. So you're talking about $35,000, right?
Right, because in this particular case, there were 7 separate claims arising out of the same occurrence. So you aggregate all 7, they recovered for 7 of those, that's $35,000. So the important point here, again, regardless of what terminology you want to use, is that where the insured paid $35,000, Mount Holly still had to pay $1 million. Its obligation was up to $1 million. That's what the policy language states.
So what's your position as to the prejudgment, when the prejudgment interest would accrue?
Okay, so that's the second issue, obviously completely distinct from the self-insured retention / deductible issue. The issue there turns on a couple of factors. Number one, the first question is this a kind of case, the type of case that falls within the category of mandatory prejudgment interest? In every case that this court has ruled in a case like this, it has found that it has awarded prejudgment statutory interest. The statute states, as relevant here, that there's mandatory prejudgment interest in any action seeking damages, quote, because of a breach of performance of a contract, which is exactly what you have here. In fact, there's not 1 but 2 breaches here. Specifically, Castle Point seeks damages because of Mount Holly's failure to defend and indemnify plaintiffs Trumbull and Alma, which breached both the policy that it issued to Vordonia and its implied contract with its co-insurer, Castle Point. Again, that's precisely why this court has unfailingly awarded prejudgment interest in cases such as this, and why the Second Circuit in U.S. Fire versus Federal Insurance explicitly rejected the argument that such actions fall within the discretionary interest category. In any event, even if this type of action fell within the discretionary interest category, the lower court abused its discretion by using plaintiff's purported delay in prosecuting the case to set the accrual date, because that decision necessarily rests on the discredited notion that interest is a penalty. In fact, as the Court of Appeals explained in Love v. State, interest is simply a mechanism to compensate a party for the wrongful deprivation of its ability to use its own money.
Well, counsel, doesn't the judge have a lot of discretion in this situation in choosing the particular interest date? And so can we say that in this particular case, Judge Reed abused that discretion?
Your Honor, again, it depends upon which category this case falls within. The judge ironically found that this case, and correctly found, I should say, that this case falls within the category of cases where prejudgment interest is mandatory. The statute says that if it's a case where prejudgment interest is mandatory, as the court found here, then it must set the date as from either the date of payment or if there are numerous dates of payment, a reasonable intermediate date. The court didn't do that. So in fact, there is no discretion in this case. The only discretion would be between setting it from the date of each payment, of which there are many, or setting an intermediate date. It didn't either. The court set a date that was years after the final date of payment here. So no, this category of case does not permit the kind of discretion that the lower court exercised.
Counsel, we're going to hear from the other side, and you'll have 2 minutes in rebuttal. Thank you very much.
Thank you. May it please the court. With respect to the deductible issue, there's deductible and SIR endorsements, there's variation. They're not standard forms from ISO, et cetera. But the defining element of an SIR is that the insurer does nothing, no defense, no indemnity, on the sidelines, no obligations until the SIR is exhausted. That's the defining element of an SIR.
Yeah, counsel, this is Judge Owing. The deductible, the insurer in that sense is reducing the amount of coverage based on the deductible, right? I mean, it's taken off the $1 million, correct? It's not the full amount. That's the difference between the deductible and the SIR.
Yes, that is entirely correct.
That's the practical explanation, I think, right?
I agree with that. In this court and in other courts in New York.
He's frozen.
I think you may have frozen, Mr. Delhunt.
Did I do something?
I don't think you could have done it, Justice Owing. But I think Mr. Delhunt.
Sorry, Mr. Delhunt, I froze you maybe with my question.
It is snowing, you know, so it's cold.
He looks like he's inside, but perhaps you can go off and come back on. There you are. Now we can hear.
All right.
Yeah, you were frozen. Sorry.
Okay, I'll channel my inner Phil Hartman and unfreeze myself. I'm sorry, I haven't had this problem yet. But I was agreeing with you, Your Honor, and I was noting that the decision.
That's what happens when you agree. That's what happens when you agree with me. You freeze.
Noted. And other courts in New York have observed that that's what a deductible is. It reduces the amount of insurance, but the limit is not the limit plus the deductible. The limit is the limit. And
so what you're saying is, for the ordinary person, if they buy an insurance policy for $1,000 with a $500 deductible and they have a loss, they're only going to get $500 back. That's what they have to understand. Is that correct?
Yes.
Well, I guess Judge Mazzarelli's question did it to you also.
I'm not going to ask any questions. I'm
sorry,
not saying anything. Still frozen.
Yeah. Is there any way you can call in? Or
maybe if he leaves and comes back, he'll be okay.
Sign back in.
Yeah.
Can our tech people help out at all, or not really?
That's
There you go. What happened?
All right. Mr. Delhunt, we're having a lot of problems with your. Whoops.
Oh, there we go. Oh, he logged out and logged back in.
All right. Are you logged back in now?
Yeah. Can the court hear me?
Yeah.
Yeah. Well, we'll try it. Give you another couple of minutes because we can't. You know.
I appreciate that. I apologize. I'm on a hard internet connection. I haven't had this problem before.
Okay.
But the point I last said, you know, that's exactly Justice Mazzarelli, how a deductible is historically understood. And as I may have been frozen, the limit is the limit, not the limit plus the deductible. And there's a difference between the limit and who's paying the limit. The deductible is the small amount usually that the insured pays either upfront or as reimbursement, and the remainder is what the insurance company is obligated to pay. And with respect to the argument about, well, how you allocate the deductible as between defense costs and indemnity, Castle Point, the thrust of their argument is you have to apply it if you accept that this is an SIR, which it is not. But if you accept that premise, the thrust of their argument is you have to, Mount Holly's obligated to allocate the deductible in the manner most favorable to the insured. Now, if that were true, that's precisely what did in fact happen, because Mount Holly took the $35,000 paid by its named insured, which is Vordonia, and applied that to defense costs, which is unlimited. Had they applied it to indemnity, there would have been $35,000 less in limits available to Vordonia. And more to the point for this appeal, $35,000 less available to Castle Point. So Castle Point directly benefited from Mount Holly's decision to apply the $35,000 towards defense costs rather than indemnity. It preserved limits for any and all insureds that would make a claim for the coverage under the policy.
Is there anything you want to say about the choice by the judge as to the interest date, since there is some discretion that was given to the courts in making that determination?
Yes, thank you, Your Honor, and I'll make it very briefly, and I thank the court for its patience. This court, and neither this court nor the Court of Appeals has held that the court is without the ability to adjust interest in an equitable contribution action. Mount Holly is not arguing that an award on that 5001 does not apply, but this court has also recognized that an equitable contribution action between insurance companies is just that. It's an equitable cause of action. That's the answer to the question. The answer does not have to come from the Second Circuit Court of Appeals, with all due respect to that court, because this court has already held, yes, 5001 law applies, but also this is an equitable cause of action. Therefore, nothing ties this court's hands to adjust an interest award where the circumstances support doing so. And the cases that Castle Point cites merely support the proposition, which is undisputed, that 5001 applies here. But none of those cases involves circumstances such as dilatory prosecution or any other circumstance that might warrant the discretionary reduction of the interest award.
Okay, anyone have any other questions? Okay, Mr. Gershwire, you have 2 minutes.
Thanks, Judge. Going back to the SIR/deductible issue, again, the question is not what word the policy uses in terms of SIR deductible. In fact, we've cited cases in our briefs that say that doesn't matter. What matters is the actual language that's used in the policy with regard to whether the amount, whatever you want to call it, reduces the limit or is in excess of the limit. The critical language here is this. It states that Mount Holly's, quote, obligation to pay damages, which means an indemnity, meaning the $1 million policy limit, quote, applies only to the amount of damages in excess of any deductible. That is, Mount Holly's obligation to pay its $1 million applies in excess of the deductible. That makes it, whether you want to call it a self-insured retention or something else, the bottom line is that language makes it clear that Mount Holly's obligation is to pay $1 million, and that obligation is excess of the obligation that the named insured has to pay the $5,000 amount. And in fact, we cited in our reply brief the one case, and Mount Holly did not cite any contrary cases. The only case we found that was published that used that precise language was an Iowa District Court case. That court said it was clear that that language means that the insurer has the obligation to pay the full limit.
If I may, please, if we accept your explanation, then what does the word deductible mean? What are you deducting it from?
It's a misnomer. That's our entire point, Your Honor. It's just because that's the word that they used makes no difference. Again, we've cited cases from the Appellate Division that found a policy that used the word deductible was not really a deductible. It was a self-insured retention. We cited that case. It's KTA Tater case. It's in our brief. Same idea. They used the word deductible, but the court said, no, this isn't really a deductible. It's a self-insured retention, and we're going to treat it as such. That's our point here. the particular term that Mount Holly used is irrelevant. What's important is the actual terminology that addresses whether this is in excess or reduces the policy. And again,
Okay,
that
Counsel.
provision makes it quite clear.
All right. Thank you both very much. We will take a further look at this. Have a nice afternoon.
Thank you.
The next case for argument is Rosafort versus Bronx Lebanon Hospital. We are ready to hear from the appellant, Mr. Robinson.
Yes, Your Honors. Good afternoon. May it please the court. I would respectfully ask that the court indulge me 60 seconds to just note quickly and briefly a few of the facts in the case. I'm sure the court is familiar with them, but they are important to the balance of my argument. The complaint, as the court is aware, this appeal is about the dismissal of a medical malpractice action pursuant to a 90-day demand. The complaint in this case, Your Honors, was served in January of 2015. That was done without the benefit of the medical records of the hospital Bronx Lebanon because they had refused to provide them. From the date of the amended complaint in this and the receipt of the answers from the defendants and the discovery request from the defendants, plaintiff provided the following discovery. On 12/30/15, plaintiff provided a response to all of defendant Jewish Homes discovery. On 1/12, and again, that was without the benefit of the medical records of Bronx Lebanon. On January 12/16, plaintiff also attempted to provide a response as best it could to the hospital demands for discovery, even though they didn't have the medical records. We also at that time provided a further response to defendant Jewish Homes request for discovery. On 8/18, there was a further response to both defendants' discovery demand and bill of particulars. On 1/14/19, there was a response to request for additional authorizations pursuant to a so ordered stipulation. On 4/3/19, there was a further response to the 1/14/19 stipulation order. To date, Your Honor, Bronx Lebanon has not provided one shred of discovery in this case, with the exception of the medical records, which were not provided for more than a year and a half after this action was commenced. There was a PC held in this case in June of 2016, and the medical records we finally got from Bronx Lebanon in that same month. There was a CC compliance conference held on 1/12/17, I mentioned before, which required a supplemental bill of particulars and set new dates for depositions. Plaintiff provided that supplemental BP and requested that defendants schedule the deposition. Now, admittedly, we were three months or so in providing that supplemental BP. However, we then requested that the defendants reschedule the depositions. They refused to respond to us for more than a year in any way whatsoever. And finally, when they did respond, the response was to serve 90-day notices.
Now, that was served, counsel, am I correct, on May 16th or on or about May 16th, 2018?
That's exactly right, Your Honor.
Okay, so what happened after that? So one of the things you're saying is that you were moving along with this case, trying to schedule depositions, going on with discovery, and then you get this May 16th, 2018, these notices, these 90-day notices, as we call them. So what did you do? You submitted an order to show cause, I believe.
We did, Your Honor. 15 days before the expiration of the 90-day period, we submitted an order to show cause. The trial court made no decision on the order to show cause for 10 days. We tried contacting the trial court to find out what was happening, but to no avail.
And ultimately, am I correct that I just want to move this along because you use up all your time, that the motion court declined to sign your order to show cause without prejudice to renew?
That's correct.
This wasn't served until later that month, and then it took you a while till you actually made a formal notice of motion.
Well, actually, Your Honor, what happened is by the time the trial court filed the denial and we found out about it, it was already past the time for the
90 days.
So in the interim, the court actually scheduled, and then subsequent to that, the motions were made to dismiss, of course, and we cross-moved to vacate. But in the interim time, the court scheduled further discovery proceedings, which plaintiff complied with.
Counsel, this is Justice Weber. What I don't understand is once you were served with the 90-day notice, why did you not just move for an extension of time to file the note of issue?
Your Honor, I kept consistently hoping that they would simply go ahead and recommence discovery. As I said before, as the notes indicate, we asked them to schedule the depositions. It was our understanding that they had everything from us in terms of discovery that was needed at that juncture.
But the CPL law doesn't really talk about, I keep hoping that you will reschedule the depositions. The CPL law talks about either filing the note of issue or moving to extend your time to do so.
Well, Your Honor, we couldn't file a note of issue. As I said before, we hadn't received one shred of discovery from
exactly. So therefore you would file a motion to extend move to extend the time to file the note of issue.
Well, we moved to vacate the 90-day demand, Your Honor. Is what we did, and the law provides you can do either or.
And this is Judge Mazzarelli. Just so that I have the time frame accurate here, you presented the court with that order to show cause before the 90 days had expired. Is that correct? 15
days before, Your Honor.
And when did you make your cross motion in relation to the 90-day period?
Immediately after the motion to dismiss was made by the defendants in the case.
Was that within the 90-day period also?
Oh, no, Your Honor, no, Your Honor. No, we were well past that period.
Okay. Mr. Robinson, we're going to hear from the other sides and you'll have 2 minutes to respond, okay?
Thank you, Your Honor.
Ms. Selmecci, are you going first on behalf of the hospital, I believe?
Whatever pleases the court, but
Sure.
I believe so.
Okay, go ahead.
Good afternoon, Your Honors. Judy Selmecci from Wilson Elster for the hospital. I do ask that the order be affirmed. I want to clear up with respect to the order to show cause. It is true that the proposed order to show cause was filed prior to the 90 days expiring. The denied order to show cause was uploaded, which is to say the plaintiff received notification of its denial right about at the 90-day mark. In response to which the plaintiff did absolutely nothing. The next move was the defendants, who didn't move right away, by the way. About a month later, the defendants make a motion to dismiss. And about a month after that.
Excuse me, why doesn't the attempt to get the motion going by way of order to show cause satisfy counsel's statutory obligations?
Their obligation is to make
an order to show cause is merely another way of noticing a motion. It's just a more expeditious way, which to me would seem wholly appropriate given what the situation was.
Respectfully, Your Honor, what the CPLR requires is that they make a motion, not propose that a motion be made by order to show cause. A motion by order to show cause.
Hold on a second. Wait, counsel,
Yes.
That's just kind of exercising form over substance. I mean, an order to show cause is basically, as Justice Mazzarelli said, it's an application. I mean, CPLR 2211 says an application is either by motion or order to show cause. So they're making an application to extend their time, the 90-day time, their time to file that note of issue. And the court declines it by saying that's not the appropriate vehicle to making that application. And I looked at 3216 and I looked at 2004. There's nothing that says that you can't bring it by order to show cause. It doesn't say that's only limited to motion practice.
Well, okay, 2203 says a motion is made when it is served. An order to show cause is served when it has a return date. It has been signed by the court.
I'm peeling it back another layer. I'm peeling it back several layers. That this is an application by the plaintiff. The court declines to sign it. So my position is, I think that the declination, there's no basis for declining to sign it. And then he not only declined to sign it, he declines to sign it without prejudice to renew on proper papers. that's it. To me, that's making more work for everybody, don't you think?
Your Honor, with all due respect, many motions for summary judgment have been denied as untimely because why? Because certain judges had part rules that required that they be made by order to show cause, and those
Okay,
orders to show
I'm
cause
glad you
were
said
not
that.
signed timely.
I'm glad you said that. The Supreme Court in this case here had court rules that when you make a 2004 application, that has to be by motion and not by order to show cause?
I'm saying that the timeliness of an order to show cause turns on when it is signed. That is why many orders to show cause for summary judgments with hard deadlines have been denied on timeliness grounds precisely because of that. It's not when you submit it to the pro se office, it's when the judge signs it. And by the way, if you're going to make a motion, it needs to have a return date. It needs to have a trigger for your adversary to respond. A proposed order to show cause does none of those things.
So let me ask you this question then. When you're running up against the statute of limitations, based on what you just said, if you're running out of a statute of limitations time, you have 1 day left to commence an action, and you commence it by order to show cause on this date.
With a TRO.
I'm sorry?
You got to do it with a TRO. If your back is against the wall like that, you need a TRO.
Wait. Let Judge Wang finish.
I apologize.
I got more facts to give you, okay?
I apologize,
So you bring an order to show cause, TRO, the whole gamut. You do everything. The court declines to sign it. You bring it on X date, it brings to the court. It's docketed as the date that you bring it. A day before your statute of limitation runs, the court declines it. Do you now have now what happens at that point?
5704, I come to your honor.
Yeah, okay. All right.
That's what happens. That the CPLR provides for this. I have done it. The order to show cause, first thing in the morning, I knew it was going to be a thing. I had my appellate papers ready, and I have come to your honors 5704. I had no luck, but I came. And that's what the CPLR provides for. And if we're talking about whether the plaintiff,
you live life too close to the edge if you keep doing that kind of stuff.
I'm just saying that since what we're talking about is whether the plaintiff exercised proper options here, he absolutely did not. A proposed order to show cause doesn't count. If it did count, by the way, the trial court, just in case he doesn't know, 5704 told him in the very long note in which the order to show cause was denied because it was defective in every possible way.
I saw it said 5704.
I know, like it was right there. So they had the option to come here. They didn't do that. They didn't do the motion by notice as they should have. They simply missed every single pitch. And then they stand here to say.
The trial court says at the very last sentence, an application for the same relief at the appellate division CPL 57048.
That's right.
Okay. I think we got that, and we'll hear from your co-defendant if he wants to add some more. Thank you, Ms. Salmechi. Mr. Visa?
May it please the court. I'm Bob Visa for the Jewish Home. Rather than launching into my script, let me try to respond to some of the questions that you've already had. I understand Justice Oing's hesitance with form over substance, but we live by rules, we live by timing rules. And if you're trying to get out from under a deadline in which you're in multiple defaults already, you need to be careful. Now, Justice Weber pointed out that the relief requested in that proposed order to show cause was the wrong relief because it asked to vacate the 90-day notices without preserving any argument or pursuing any on appeal as to the validity of those 90-day notices. It's conceded that they were properly served and that they did properly start the clock. It's not as if you didn't have all of the technical requirements satisfied in the statute, 1 year from joinder of issuance, manner of service, and so on. That's all by the boards. We got valid 90-day notices. There's no grounds to move to vacate. Now, what happens then is the court also granted relief under 3124 and 3126. Nothing to do with the 90-day notice, nothing to do with the form over substance, the timing of those things. It had to do with the fact that the defendant served demands in February of 2015. In a May 2016 stipulation, so now we're 15 months later, plaintiff stipulates to provide the information in those. That's at our 384 in the record. It's a 3-page stipulation. It appears in multiple places in the record, but as you have it in the record, there's only one copy. There's no dispute that it is the stip that was signed because it's in other exhibits. In that stip now, in May of 2016, counsel is agreeing to provide certain things that years later, in an April 2019 response at 469, suddenly says, oh, I don't know. I don't know who those doctors are. I can't give you those authorizations after so many years have gone by. Had they consulted with the client back at the time the demands were served in February 2015, we would have tried to have some other way to figure that out or find that out, whether it was from collateral source or other records.
Obviously, this was, there's a decedent involved here, but what was the relationship of the person that was the administratrix? Was she a family member or a friend? Do you know?
That's what I was going to ask, counsel. I thought the reason that they had problems or issues in terms of obtaining these authorizations was that the relationship was that she was a friend, and therefore she was not necessarily privy to the medical care of the decedent.
We then were prejudiced by that because had we been told in 2015 that the friend didn't know, maybe we would have had 4 years of a chance to try to investigate. Well,
that was going to be one of my questions to you, counsel, in terms of what exactly is the prejudice here? I mean, do we look to whether there's any prejudice? And if we do, then what exactly is the prejudice?
Sure. Well, you've got underlying comorbidities and medical conditions here where in any bed sore case, any decubitus ulcer case, or arrive at the nursing home over the 2 days, you've got to look at the surrounding medical conditions and, the skin is an organ. If the patient is not healthy, we need to know about the cardiac situation. We need to know about perfusion. We need to know about these things in order to say, hey, did this happen in the absence of negligence, or was it the result of what was?
So she came to you. I'm sorry. She came to you from Bronx, Lebanon, right? Or did she start at it with you and then go to Bronx, Lebanon?
No, I believe, according to the dates of treatment alleged in the complaint, were March through May of 2013 at the co-defendant hospital, and then April 23 to 24 of that year at the New Jewish Home. So
you would have been privy to the medical records from Bronx, Lebanon when she came to you at Jewish Home and Hospital, right?
The transfer summary usually just has a physician review instrument, a PRI instrument that's like 20 pages, but we don't get the whole chart ordinarily. We get maybe a medication summary. So
but you have your own charts over there at Jewish Home as to the care that she's receiving and whatever. I mean, you certainly have access to some of those charts.
Yes, right. But now I'm trying to defend a 2-day window without the rest of it. I'm sorry.
Also, if your physicians feel that they haven't got enough information from the hospital, they would seek it, wouldn't they? They wouldn't just take a patient blindly, I am assuming.
True, but the issue here is whether the trial court appropriately exercised discretion.
I understand. I know what the issues are, the legal issues, and that wasn't what I was asking you.
So, but counsel,
you said all you get is a summary, and that's what I guess that's what you're going to argue you base your treatment on. But my question to you is, if your physicians feel that they need more information, they know the hospital from which the patient came, and they can get that medical information from them.
I appreciate that, Justice Mastroelli. I'm sorry to seem as if I was avoiding the question. In order to defend this case at trial, if I'm talking about causation, I'm not talking about what my practitioners were thinking or knew at the time. I'm talking about what my experts can say were the underlying comorbidities that caused these injuries in the absence of negligence. And appellant has the burden of demonstrating that Justice Capella in the trial court abused, essentially, or improvidently exercised, in modern parlance, the discretion. And there's no argument preserved in the trial court and none pursued in the appellate court as to that appropriate exercise of discretion.
Are there any other questions?
Yeah, I just have one question. I mean, I just wanted to know that this wasn't a draconian decision, because even after you moved to dismiss based on the 90-day notice and there's a cross motion to vacate, you guys had a stipulation where there was like a last chance type of let's try to work this through and get this done so we can get this case moving and back on track. And that just wasn't going, somehow it wasn't getting on the train track. It wasn't moving anywhere. And that's when you finally renewed the motion and said, okay, you know, enough is enough, I'm done. Right? I mean, there was a last minute opportunity to try to get everything back in order, correct?
Yes, Justice Owen, you have a very good intuition about that. If you look at the timing of the notices of motion, I lay it out in my brief in the fact summary, but yeah, we hesitated on the motion and we had multiple court conferences until it became apparent that what was being stipulated were things that we might never get. Obviously, there was never an excuse for not being produced for the deposition and so on and not getting things moved forward.
Okay, thank everyone. No more questions? Okay, Mr. Robinson, you have 2 minutes on rebuttal. You're muted, Mr. Robinson.
I'm sorry. Thank you very much, Your Honor. First of all, let me correct one thing very quickly. There was a statement made that the decision that we found out about the denial of the order to show cause within the 90-day period. That's absolutely not true. I suggest you take a look.
Mr. Robinson, this is Judge Owen, but you don't deny the fact that after they made the motion, you made the cross motion, that there was an attempt, there was a stipulation that kind of resolved their application to have the case dismissed, or their application to have you put your file your note of issue. There was a stipulation. There was an attempt to work things out. Correct?
Absolutely, Judge, and we complied completely with that.
So did your client appear for a deposition? Is there anything in the record that indicate that there was a deposition held for your client?
They refused to go forward with any depositions once that stipulation was signed, because in fact the Jewish Home hadn't even submitted a motion at that point. They then submitted a motion after that and decided that they were not going to comply. They wouldn't comply with that stipulation, not us. And may I point out one other quick point?
Well, let me ask you this question: when they moved again, because apparently they had to move again to dismiss, did you make another cross motion when they moved again to dismiss?
No, there was only one cross motion to dismiss. I mean, there was only one motion to.
I understand that, but after the stipulation, according to this, March 29, 2019, the Jewish Home moved to dismiss the complaint again. So did you move by cross motion at that point to explain that what you just said to me, that they wouldn't take the deposition of your client?
That's exactly what I'm telling you, Judge. They refused to go forward, Judge.
I know, but did you cross move again? They made a motion on March 29, 2019 to dismiss.
I believe that was an amended motion.
You're not answering my question. Did you cross move then?
I believe my cross motion was after both of those motions, Judge.
Okay. All right, thanks.
One other point I would like to make with respect to Judge Owen's discussion with opposing counsel regarding the 5704 motion. You can't make a 5704 motion until the trial court denies the order to show cause. We didn't find out about the denial of the order to show cause in this case until after the 90-day period in this case here. So we could not utilize a 50.
I thought that your adversary stated that it had been uploaded within that 90-day period.
Absolutely not, Judge. If you'll just look at page 243, the period ended on August 16th. This was not uploaded until August 20th, 2018.
It was denied on the 10th, but it wasn't uploaded until the 20th. Is that correct?
Yeah. Oh, we would have rushed right out and done a notice of motion. If I have any additional time, also, I would like to say with regard to
just have a minute, okay?
All right. Thank you very much, Your Honor. With respect to Mr. Viz's comments regarding prejudice to them, they had access to these medical records as you indicated before, and we were not able to provide any additional information to them because in this case here, the plaintiff is merely a friend of the deceased in this case here.
But I think the point was you didn't tell them that. I think what he's stating that you didn't respond by saying, well, we don't know, but you actually know because you actually treated her.
But we did respond to that. If you'll look at our responses, you'll see that we did say that.
That we don't know?
That's correct.
All right. Well, thank you, Mr. Robinson and defendants counsel. We will take a look at all these documents.
Can I say, Ms.
I'm sorry.
Ms. Summucci, could you do me a favor and turn your background, flip it for the next argument? It looks like it's a Russian.
Thank you.
Yeah, I was going to tell you that 2 weeks ago. It looks like a Russian broadcast or something. And I meant to tell you that 2 weeks ago, and then you came back. And said,
Thank you, Your Honor, for saying something. I absolutely will. Thank you. Thank you.
Sorry, Judge Weber. I'm sorry you would say that earlier. Okay, thank you very much.
Thank the court.
Okay, our next argument is on the Bankers Conseco versus Wilmington Trust case.
Thank you, Your Honor. May it please the court, I am Joseph Buckley for plaintiffs' appellants. There is no dispute that plaintiffs sufficiently alleged that Wilmington breached the 4 trust agreements in which plaintiffs were beneficiaries. The complaint alleges that Wilmington breached Section 2.1b, requiring it to reject and return non-negotiable assets at least 33 times. Many, if not all of these 33 sizable assets were non-negotiable on their faces. The motion court accepted Wilmington's affirmative defense that damages claimed in the complaint are conclusively barred by the language of the trust agreements, which prohibit consequential damages. This was error. The Court of Appeals in Biotronic teaches that general damages are the natural and probable consequence of the breach. And while the distinction between general and special contract damages is well defined, its application to specific contracts is usually more elusive.
So I know there was a lot of discussion about the direct damages, the consequential damages, whatever. What are the damages? Can you point to me where in the complaint that could fall into direct damages that you sought in this complaint?
Yes, we allege 3 such categories of direct damages, Your Honor. First are the direct damages suffered each time that a non-negotiable asset was placed into the trust, because the asset was worth intrinsically less than an otherwise identical asset in negotiable form under the authority of Latham Land and so forth. This is a direct damage. The assets were worth that much less because Wilmington failed to check for their negotiability. We're not claiming that they're bad assets otherwise and that's Wilmington's fault. We're only specifically seeking, and we would do so through expert testimony, the amount of damage that was suffered by the beneficiaries at the time these assets were placed into the
because trust. They weren't negotiable. Is that why?
That is correct, because they non-negotiable assets are inherently worth less. Okay. And as we pleaded, our second category of damages is we had to pay substantial fees when we recaptured these assets in order to obtain negotiability. And the third and final category of our direct damages are the attorney's fees that we were required to bear, not as was argued by the Wilmington's brief because we chose to, but because we were compelled to hire attorneys, Fried Frank and other attorneys, to make sure that these assets could be negotiated in order that they'd be disposed, which we had to do upon recapture of the assets from Wilmington. And all 3 of these categories we submit are direct damages. The first of them, the diminution in value, we think is clearly direct. It doesn't require any kind of discovery. The third category, attorney's fees, the courts have from time to time held that attorney's fees may be consequential damages. In fact, there's an appellate division case referring to that in dicta. But they also may be direct damages, and they're direct. And we would like discovery to show that that we were in fact compelled by the regulators to engage these lawyers to recover, to make sure that these assets weren't negotiable. And whatever funds we spent that we were compelled to spend should be direct damages because they're the natural and probable consequence of the breach by Wilmington.
What now? Could you address somewhat the breach of fiduciary duty? Is that duplicative in this case? Is it not duplicative?
Well, it's duplicative in the sense that it's based upon the same facts, but it's not under the Apple Records case in the First Department. The issue is whether the same conduct violated a separate duty. Yes, it's the same conduct, but again, Wilmington here, it's Wilmington Trust Company, and they were by law, by regulation, the trustee of a trust in which we were the beneficiaries established under New York and Indiana regulations. And it's our allegation that they violated their trust duty. Now, they've claimed they've disclaimed their fiduciary duty, but you can look far and wide in the trust agreements. There's no specific disclaimer of fiduciary duty in the trust
What
agreement.
is the difference, counsel? What is the difference in damages between the two causes of action?
Well,
What different
between fiduciary
damage would you recover under a breach of fiduciary duty?
I mean, essentially, we're saying it's the same damage, but under a different theory. Although we believe this is important because if the case is remanded for trial, there's a looser standard for damages under fiduciary trust law. But Your Honor, it is in effect the same three theories of damages we would be seeking.
Could you argue that what might be characterized as consequential damages under a breach of contract claim could be recovered under your breach of fiduciary duty claim or not?
I mean, it's possible there are circumstances where that could be true, but at this point, we believe that direct damage, that certainly our first category of diminution in value is classically under Latham Lamb of direct damage, and the other two, once remand is, if the court grants remand, would be deemed to be direct. I mean, in theory, could there be a basis to waive I don't think either side's really briefed that point on this appeal, though. Yes, in theory, there could be, but we're not advocating that today.
Thank you.
Any other questions for Mr. Buckley? All right, you'll have a few minutes in rebuttal, Mr. Buckley. Thank you very much. Okay, Mr. Durland?
Thank you, Your Honors. Good afternoon. I think I'll start with the question of consequential damages, and in particular, the test that the court ought to use to distinguish between direct damages and consequential damages. The cases agree that direct damages represent the value of the promised performance, whereas consequential damages are a step or more removed from the breach. Now, my friend is suggesting that the category of direct damages ought to be defined using the definitions for contract damages, money necessary to put the non-breaching party in a position it would have occupied but for the breach, or, as you heard just now today, using the definition of proximate cause. But if that's the definition of the subset of direct damages, then there's no such thing as consequential damages. Any loss that falls outside their definition of direct damages isn't recoverable anyway, because it's either no proximate cause is satisfied or because it doesn't qualify as a contract damage. What the court needs to do to assess this legal question about do we have direct damages alleged here or contract damage, or excuse me, consequential damages, it needs to ask, are there any intermediate steps between the alleged breach, which is Wilmington's acceptance of non-negotiable assets into the trusts, and the alleged losses here? And
how could we say that if there was supposed to be non-negotiable trust? The claim is that you accepted into the trust some not freely negotiable assets, which were not supposed to be accepted.
Correct.
By accepting them into the trust, and they became part of the assets, they were not as valuable as if they had been freely negotiable. How much more direct could that be? They took stuff that wasn't what they were supposed to take, and that stuff wasn't as valuable as the stuff you were supposed to take. So what step? I don't see any step in between there. So they're not negotiable. Why is that not arguably a direct damage?
Because, Your Honor,
allegedly did, yeah.
Because that stuff was not the insurers. This is probably the most critical point on this appeal. That stuff, those trust assets, were not the insurer's assets. So, again, you see.
Why does that matter?
Well, because the reason.
In the scheme of what the relationship was here, they had these assets. You were supposed to. You were supposed to accept certain types of assets in, and they became less valuable because you accepted the wrong kind of assets. What does it matter if they own them specifically or not?
Well, it matters because the diminution in value only matters to the owner. A diminution in value doesn't matter if those assets aren't yours. And this is a critical point. You see the insurers say,
whoops.
The moment a non-negotiable asset hit the trusts, we were damaged because those assets were ours all along. That is fundamentally inconsistent with the agreements, Your Honor. 2.3 of the reinsurance contract says the trust assets are paid to Beechwood as consideration for Beechwood accepting the reinsurance obligation. Likewise, 4.2 of the reinsurance contract says that Beechwood has a beneficial interest in those trust assets. Similarly, the commission that's paid into the trusts, that commission is the fee given to Beechwood as part of the consideration for it taking on this reinsurance obligation. And the insurers themselves in the parallel federal litigation made this exact point. They said, we, quote, transferred nearly $600 million to Beechwood through the trusts. That's page 414 of the record. Again, in a similar vein, these trust assets are collateral. They are the insurer's security for Beechwood's reinsurance obligation. Well, collateral only gives security to the creditor because the creditor can say, if you don't pay me from this pocket, I can get my money from this other pocket. But on the insurer's conception, if they were right that these trust assets were theirs all along, then their security interest lies in their ability to reach into their own pocket, to take their own money out and move it to a different pocket. That doesn't make any sense. And once again, the litigant who made this point most eloquently is the insurers themselves in their platinum brief, where they say, they describe the recapture as them taking a debtor's property, that's Beechwood's property, to enforce an antecedent debt, page 430 of the record. So the reason that this point is so critical, Justice Kapnick, is that because the insurers did not own these, they did not have the beneficial interest in these properties, the diminution in value is irrelevant to them, just like a bank holding a mortgage, again, an analogy that they used in the federal litigation to describe the nature of this transaction. When a bank is holding a mortgage, diminution in the value of the property that's held as the collateral doesn't work a direct injury to the bank. It only works an injury if circumstances arise such that the bank has to foreclose on its collateral. And here, those circumstances didn't arise until, first, the insurers fall asleep at the switch. They let Beechwood make speculative investments. Second, state regulators object to those investments and say, you need to fix the problem, or you're going to face the loss of your reserve credits. And third, the insurers say, we can't fix the problem on the regulator's timeline. We've got to foreclose on this, our security interest, take these assets back from Beechwood, back onto our books. And it was only at that point that these alleged losses, this alleged diminution in value, has any impact on the insurers. Before that point, they are no more than secured creditors sitting on the sidelines. And of course, as I said, the loss of value in the trust assets may have set the stage for a potential future loss, but that loss did not materialize, or that risk did not materialize until the recapture. And again, that recapture is the tail end of this three-step chain reaction. Remember, Your Honors, before the recapture, it's Beechwood that gains if the trust assets rise in value above the contractually specified threshold, because they get to withdraw the surplus, and it's Beechwood that loses if the trust assets fall below the contractually specified threshold. Like, for instance, if Beechwood buys...
To me, and maybe you can explain to me why my interpretation of what you're saying is wrong, but it's almost as if you're arguing that there's no theft until the theft has been discovered, even though there was a theft.
Well, it's not discovery, Your Honor. If you're going to say, I was injured by the reduction in the value of this asset, it better be your asset. It's like if I take property from my neighbor, a different neighbor.
If the Department of Financial Services, I think it's called now, requires that they hold certain types of assets so that they can secure payment of these long care policies. And in fact, what they have in their pot is not what they're supposed to have. That, while the injury may not have been realized in the sense that you're talking about it, they've been injured nonetheless, because if the time comes that they need to make those payments, they're not going to have the ability to make the payments. And the people that are being insured are going to be left without being able to get what they're paid for.
Well, first off, Your Honor, we need to distinguish between the eligibility, the riskiness of the investment, and and as opposed to the allegations here, which is merely the negotiability, the ability to freely negotiate the asset. But nevertheless, I take
that's what they're required to have. They're required, as I understand it, they're required to have freely negotiable assets so that they can negotiate them should the need arise.
Well, that's correct, Your Honor, but it's really important to recognize here that those assets that we're talking about, the loss claimed is a loss in value, and that value only comes home to the person who has the equitable interest in the asset. And these agreements, as I said, the beneficial interest, 4.2 of the reinsurance contracts, it's held by Beechwood until the recapture. And that recapture is the tail end of this three-step chain reaction, and those are the steps removed. If I could use an analogy, Metropolitan Life, Court of Appeals decision. You've got, as it happens, an insurance company that's the plaintiff, hires a software vendor to give it some software and customize it to the insurer's needs. At some point, the vendor says, this is costing us too much money. If you want us to finish the job, you've got to pay us more. The insurance company says, no way, and it pays someone else to finish the job. Now, on the insurer's conception, I think some of the questions would suggest, well, hey, that's the exact same thing that they hired you to do, software vendor. That's got to be.
Sound to me to be the same. The analogy that you're making now doesn't sound to me to be anything like the situation we have in front of us at all. But that's just my perception.
Well, Your Honor, this
why don't you finish up after this, okay, Mr. Derland?
Certainly, Your Honor. The reason I think the analogy holds is that the suggestion here is that, of course, it's got to be direct because they had to pay somebody to do exactly what you were supposed to do. But in Metropolitan Life, the Court of Appeals holds no, those are consequential damages. It's a step removed. And at the very least, these payments to third parties are yet further removed. And those absolutely need to be upheld as contrary to the consequential damages waiver.
Okay.
We request that the court affirm the judgments below. Thank you very much.
Thank you very much. Mr. Buckley, you have 2 minutes to rebut.
Thank you, Your Honor. We certainly agree with Justice Mazzarelli, and I would go even further in that the Wilmington is misstating the regulations in the trust agreement. It's true that the plaintiff appellants are secured creditors in a separate agreement, but under this agreement, this is a trust where our clients are the beneficial owners of these assets under the trust. And by regulations, which we cite in our brief at Reg 114, as beneficial owners, we have the right to withdraw these assets at any time for the benefit of our policyholders. We're not like a bank in that sense because we still have duties to our policyholders.
But you're saying you're the beneficial owners, but you don't actually own these assets, correct?
But we have the right to withdraw them at any time in order to satisfy claims to the extent they're not made. So we're not like a bank whose collateral might be impaired. I mean, these are our policyholders, in fact. So the regulation, this is different than a bank. We have the right to actually take the money out. So they, in fact, want to tell us how we would do our expert report on remand, but we would do it this way. We would say that our loss is suffered on the date that Wilmington breached because there's an inherent lesser value and it's not just collateral. These are assets that we're the beneficial owner of and we can withdraw at any time. And let me say finally that their argument really would confound the entire regulatory scheme because under the regulations, they must be responsible for their own negligence. The regulations say it and it's in the contract. And yet they're trying to define consequential damages in such a way that they would have we would have no damages whatsoever. It's not the intention of the contract. And they've made this argument that well, we can measure it by what fees were paid. But their fees were paid by Beechwood, not by us. Beechwood negotiated that deal. We didn't. So we don't even have a claim for their fees. Their argument just doesn't hold water.
Okay. Thank you, counsel. Thank you both very much. We'll now hear on the related case, the Bankers versus Egan Jones. And I guess we have a different attorney for plaintiffs on this case. Mr. Epstein.
Yes, good afternoon. If it may please the court, I am Richard Epstein for the plaintiffs' appellants. This is the case where the motion court dismissed the wrong pleading, focusing only on the original complaint rather than the operative amended complaint. But I don't want to spend my time today on that error. I'd rather spend it on going through the amended complaint to show that the amended complaint adequately pleads all three elements of an aiding and abetting fraud claim. So let's start with the first element, which is alleging an underlying fraud. And again, here the motion court was focused on a fraud that occurred in 2013. Respectfully, that's not the fraud that is alleged in the amended complaint. The fraud that's alleged in the amended complaint occurred in 2015 and 2016, which is a fraud whereby Platinum, the bad guys, used Beechwood to stuff the trusts with junk assets. And then Beechwood misrepresented, falsely stated to us that those trusts were in compliance with the guidelines and the regulations. As we all know, trusts for this type of a transaction have to be primarily investment grade assets. There's very little high yield assets that are allowed because these are backups for the benefit of the policyholders. So here you have in 2015 and 2016, junk assets being stuffed in. But the bad guys couldn't just do it on their own say-so. They needed to have a name, somebody independent, an NRSRO, to provide ratings that would show that this junk was actually, at least as rated.
I guess to your point, counsel, this is Judge John. I guess to your point is that's why they went to a third tier ratings agency instead of the top tier rating agency. That's the sense I get. That's the insinuation I get when I'm reading the amended complaint, that they went for the B team instead of the A team.
You know, Justice Ong, I want to agree with you, but I'm afraid I'll freeze if I end up agreeing with you.
Fair enough.
So let me try it like this. They certainly went to an entity that was among the smaller NRSROs, one which would be more in need of the business.
They only had 25 employees.
That is correct. Yes, Your Honor. And like I said, there are about 10 NRSROs. Only, you know, this is among the smaller ones. It's not like a Fitch or a Standard & Poor's or something like that. So let me move on.
I like the amended complaints allegation in paragraph 63, where you have not one, but 5 exclamation points to phenomenal, which was the description that the Beechwood guys gave the report.
Well, that's actually, Justice Ong, that's not my just being using too many exclamation points. The document that we're basing it on, I'm just quoting it accurately. And that's one of the, we give 6 examples of inferring actual knowledge. And we can all agree under First Department case law, defendants rarely admit, yes, I had actual knowledge. So you have to do it by inference from the surrounding circumstances. So the 3, I've given 6 in the complaint. The 3 that I'd like to focus on today are 1, the objectively unreasonable ratings that Egan-Jones gave. And we've given several examples of entities that were really bad, and yet they got investment grade ratings. 2, you have the fact that Egan-Jones, unlike my clients, knew that Platinum owned and controlled Beechwood, and yet rated these assets as though they were completely arm's length, having nothing to do with Platinum. And 3, the fact, as we've alleged in the complaint, that there were 3 assets rated where Egan-Jones gave them a lower rating. Beechwood and Platinum said, no, that's not going to help us. And all of a sudden, after a phone call, voila, one of the assets goes up 3, the other goes up 2, another one goes up 1 notch. I mean, just based on that alone, you have enough to infer actual knowledge. In fact, in almost the same way that you do in the William Doyle case, where we can infer actual knowledge on the bank's part because they had the means to verify this, and yet they did stuff that was not particularly appropriate. So you have actual knowledge, you have an underlying fraud, and then you need substantial assistance. Here's the substantial assistance. It's the ratings. It's, like I said, it would be one thing for Beechwood to just say it. No, that would not have been sufficient. My clients required, the agreements required that you have a rating from a credible NRSRO, purportedly independent agency. Here, the ratings confirmed the representations that were being made, excuse me, the false representations that were being made. And in that case, it's kind of like the IDK case where Justice Weber was on the panel, where, you know, the fact that the credit rating said this means that you don't have to go any further. It's reasonable to rely on that. So my last point would be that, you know, I want to go back to the motion court's decision. And in that decision, the motion court said that we are going to dismiss this for basically the same reasons as in the KPMG case. Well, on December 1, 2020, the First Department reversed the KPMG case dismissal, finding that the complaint there adequately pled all three elements of an aiding and abetting fraud claim. I think it's exactly the same here. We've adequately pled it. Whether we can prove it, that's for trial. But under 3211, we've adequately pled it. Thank you.
Thank you very much. May I hear from Mr. Leghorn?
Good afternoon. May it please the court. This is Thomas Leghorn for the respondent, Egan Jones. Let me start off with the last point made. The KPMG decision by this court has nothing to do with the claims as against our client, Egan Jones. And the distinction is because KPMG, from the record that was before the court in rendering that decision, was involved in the initial valuation, which plaintiffs, the appellants here, were relying upon to enter into the reinsurance agreements at issue. Almost 2 years pass after that, the reinsurance is in place, and Egan Jones, a rating company, is called upon to rate the collectability of certain loans that are being used in Beechwood. And because Beechwood is a reinsurer, they have to meet regulatory guidelines, and it is commonplace for a rating entity to agree to have these ratings posted on the websites of the appropriate regulating authorities. And that's what was done. This was disseminated for general use in the ratings by the regulatory authorities, and it was not used for purposes of inducing anyone into a contract. Counsel points to three reasons as why there was knowledge of the fraud. First of all, to the extent that a fraud existed, it was with respect to the reinsurance agreement. I still believe that the fraud has not been shown or properly alleged in connection with what happens afterwards. And I say that because the elements of fraud requires that bankers has to point out what facts were stated to them afterwards that were untrue of a existing fact upon which they relied. Well, that's a material element that's missing and can never be done, shown in their case, because as referenced in our brief and in the record, in all of these litigations that they have started, they make an acknowledgement in the litigation with the reinsurers that they quickly had concerns and suspicion. And so clearly they were not relying upon anything after that point to take further action. The die had been cast. And in their attempts to say, okay, we're going to cite all the cases, say I need to prove actual fraud, but now I'm going to put all these points in there, throw everything at the wall so that you believe.
But the thing is, as to your client, this is just an aiding and abetting fraud. Those are different claims. So yes. I mean, we don't have to really deal with the main fraud claim. I know there has to be a fraud claim in order to be aiding and abetting fraud, yes. But we're just getting to your client and to the specific allegations as to your client on the aiding and abetting claim.
And yes, Justice Kaepernick, that is exactly right. And appellants have conceded that the underlying fraud is not what they're basing this on. It's the fraud that they say comes later. And that is what I'm saying has not been established, because it is not enough to allege that our clients did something wrong. They have to show it substantially assisted in underlying fraud. And I'm saying that that second fraud is what's missing. It's just this whole conglomeration of all this conjecture, conclusory statements. And let me just quickly turn to, the 3 points to raise. Objectively unreasonable ratings. We are a ratings agency. And from Supreme Court, U.S. Supreme Court law, their opinions, they are protected by the First Amendment. And with hindsight, if you disagree with them, that doesn't make them actionable. And they argue that Egan-Jones knew of the relationship between Platinum and Beechwood. Well, that too, is just, it doesn't do anything as to furtherance of the aiding and abetting, because they are looking, Egan-Jones is called upon to say, what is the likelihood this loan being extended is going to be paid? They are not doing SEC due diligence. They're not doing anything like that.
But what about his claim that your client knew about the relationship that Platinum had with Beechwood, and that your client actually changed some of the ratings after they were told by Platinum or Beechwood or somebody that these aren't good enough? Now, those are allegations that he's making. This is only a 30-11 motion, but based on some of those allegations, why would that not at least be enough to allege? And he's given the basis for those allegations.
Okay, so two things are put there together. The relationship between Platinum and Beechwood, it doesn't move the needle one point or the other. But the change of the ratings, what they've pointed to is that a rating company does an initial draft based upon the information they have, and then they present it. And what was changed? It wasn't, there's no allegation that these weren't good enough. That's not in the complaint. That's not in the record. What it is that they make this supposition that this is what must have happened, but rather the draft reports were put out there and saying, we're going to give it this because of these questions. And in the follow-up phone calls and information, in some instances, those questions were answered to a greater satisfaction than the other. And the final reports from now, there is no allegation that a report that was issued was ever changed after it was issued to the public and posted.
Okay, do any of my colleagues have any more questions for counsel? All right, thank you very much, Mr. Leghorn. Mr. Epstein, you have 2 minutes for rebuttal.
Thank you. Let's start with actual knowledge, because it's pled directly in the amended complaint that these ratings were unwarranted, they were bogus. And I'll give one example, because it's one of the three where they increased the rating, and that is the implant asset. And this is alleged at paragraph 69. That had been a company that was a distressed defense contractor that had negative earnings for several years and which had been delisted from the New York Stock Exchange. So the reasonable inference at this stage is that that was a knowingly unwarranted rating, let alone an increase in the rating after a conversation with Beechwood. And that gives rise to a reasonable inference of actual knowledge. Now, I just want to be clear on one thing. A reasonable inference is not the only inference in the world, but on a 3211, all I need is that one of the reasonable inferences is this. In terms of the underlying fraud, we have pled it. It's a fraud in 2015 and 16, misrepresenting that the assets in the trust were compliant when they were not. And just like in the Madoff case, you can have different frauds at different times. You have the fraud in Madoff in inducing the investors and then giving them later on the phony reports on how their investments were doing. Finally, I would just like to cite the court to the First Department's decision in the AIG case, which we quote extensively in our briefs, which is a case that says that the actual knowledge was adequately pled, where a rational inference of actual knowledge could be drawn from the surrounding circumstances, meaning the conduct of the defendant. It's circumstantial evidence at this stage that is sufficient. Unless the court has any further questions, I'd like to thank the court for all the time it's given us this afternoon.
Okay, thank you all very much, and we appreciate your coming in. Have a nice afternoon. The next case is Rosario versus State of New York. Appellant.
Good afternoon, Your Honors, and may it please the court. Richard Rosario is an innocent man who spent 18 years wrongfully in prison for a murder in the Bronx that he had nothing to do with. There is no dispute in this case that Mr. Rosario has put forth detailed allegations that prove he was not only innocent of the murder, but he has 13 alibi witnesses who can show he was in Florida at the time of the crime. The only dispute here is whether this innocent man can be precluded from proving his innocence and seeking a remedy in the Court of Claims because the court's vacant order in this case lists ineffective assistance of counsel, despite the fact that Mr. Rosario has put forth documentary evidence showing that the actual reason his conviction was vacated was newly discovered evidence of his innocence.
So, Ms. Green, aren't we bound to comply, to follow by the decision of Judge, I think it was Judge Torres was the one that wrote that last decision, where he said this was based made it very clear that this was based on ineffective assistance of counsel, and we're not the legislature. So the legislature did have certain exclusions from the Court of Claims statute, and one of them is ineffective assistance of counsel. So how do we get past that?
Your Honor, you are not bound by the decision on the motion to amend, because at the time of the motion to amend, the Bronx District Attorney's Office was in possession of newly discovered evidence pointing to a different perpetrator that was not disclosed to the court and was not disclosed to the defendant. But what we know is that is the evidence that actually prompted the Bronx District Attorney's Office to consent to vacatur in this case. And you have to keep in mind that actual...
Excuse me, Ms. Green, this is Judge Weber. So wouldn't your remedy then be that you would have to move to vacate Judge Torres's decision, wherein he found that it was solely based upon ineffective assistance of counsel? Would you not have to move to vacate that, and so that he would be able to make a determination that it was something other than ineffective assistance of counsel, which falls under the Court of Claims Act?
No, Your Honor, we do not need to move to vacate the decision, because the precedent of this court says that you look at the actual evidence that prompted the vacatur, and that this court can look actually to the record here, and we presented.
So you're asking us sort of to like look behind what Judge Torres found in his decision and decide that the Bronx DA really did it for this reason, even though Judge Torres based his decision on ineffective assistance. I mean, how do we know really what they were talking about behind the scenes? How can we figure that out? Even if you're correct that some of that evidence was presented, how can we go behind what the decision says?
Your Honor, at the time of the vacatur was based on a consent motion, consent of the DA's office. It was a one-paragraph decision. There were no findings. There was no findings about why counsel was ineffective. And what we know is that the district attorney's office had spent 13 years contesting and litigating that Mr. Rosario did not have a claim for ineffective assistance of counsel. What actually happened here is the Bronx District Attorney's Office conducted a reinvestigation of the case and learned from unimpeachable witnesses, the victim's family members, that there was evidence pointing to a perpetrator different than Mr. Rosario.
I don't think there's any, Ms. Green, I'm sorry. I don't think that there's any real dispute about that. I don't think that it's any in dispute that your client was subject to wrongful conviction. I think we can all agree to that, okay? The issue becomes, Justice Torres specifically stated, and I think, I think there was a question to him. He specifically stated that it was based upon ineffective assistance of counsel. He explicitly rejected a newly discovered evidence ground for vacator and said it was solely as to ineffective assistance of counsel. So again, what you are asking us to do is to review that entire record as to Mr. Rosario's wrongful conviction, make a determination that it was something other than ineffective assistance of counsel, make a determination that it was something of prosecutorial misconduct or something of that nature, which would fall under the Court of Claims Act. And I don't believe that we have the authority to do so.
Your Honor, Judge Torres did not have a complete record at the time of vacator. And the reason the judge didn't have a complete record is because the evidence that the Bronx District Attorney's Office had uncovered was not disclosed.
And so that takes us back to Judge Torres's decision. And so I say to you, it seems to me that you are in the wrong court, that you need to go back before Judge Torres and say, when you made this determination, vacating the conviction, you were not fully made aware of X, Y, and Z. And therefore, you should now that you are made aware of X, Y, and Z, you should now vacate based upon something other than ineffective assistance of counsel.
Your Honor, if all can agree here that Mr. Rosario is innocent,
but we're bound by the statute, and the statute does not allow for claims for based upon ineffective assistance of counsel.
Your Honor, you are not bound by the statute. It is this court's prerogative to interpret the statute in a manner that is consistent with innocence. Here, if there is no exception, when there is actual evidence showing that the vacator was newly discovered evidence, an 8B enumerated ground, that would lead to the absurd result that a prosecutor's office could intentionally suppress evidence under enumerated ground and prevent a person from coming to the Court of Claims and proving their innocence. And this is not new. I'm sorry.
All right, you'll have 2 minutes to respond, Ms. Green. Thank you. Ms. Olson, Ms. Olson, go ahead. You have to unmute. I wanted to ask you a question before I forgot it. Am I correct in reviewing the record? I made a note. I don't exactly know where it came from in the record, that Judge Torres at some point specifically denied Mr. Rosario's request to amend the order granting the motion to vacate to add the ground of newly discovered evidence. Did that happen? Am I correct in making that note?
That is absolutely correct. Correct, Your Honor. Mr. Rosario initially moved to vacate his sentence on an unenumerated ground, ineffective assistance of counsel. That was granted. He then subsequently moved to add an enumerated ground, newly discovered evidence, and after an impartial adjudicator in an adversarial context reviewed the entire record and dug into the facts, the court very expressly said, newly discovered evidence is not supported here. And Justice Weber, you were exactly correct that if Rosario believes that there was some kind of, that his situation is now different for some reason, his remedy is to go back to Justice Torres and not in this court. And that's because the way that the system is set up is under the Four Corners rule, under the sections 8B and under this court's decision in Green, it leaves defendants like Rosario with multiple avenues under the CPL and in Supreme Court to go back and just add enumerated ground if they want. We know, for example, from Baba Ali, that courts are eminently capable of identifying multiple grounds for vacature when it is appropriate. That was a case.
Ms. Olson, I noted that your adversary in their papers, and I think she was just arguing this as well, that, which I find to be an interesting argument, that the prosecutor could then consent to the vacator based upon claims that were not enumerated, that are not enumerated in the statute. However, I want to be clear. There's nothing that requires the people's consent, is there? Could not, I mean, even if you did that, I, as the judge, if I were Judge Torres, or Judge Torres in that circumstance, he would not be bound by whether you consented or you did not consent. So if that judge made a determination based upon the facts, regardless of what you said, you prosecutor said, that in fact it was newly discovered evidence or something other than ineffective assistance of counsel, he or she could vacate the conviction based upon their own evaluation of the record. Is that correct?
That is absolutely correct, Your Honor. The court is not bound by the prosecutor, whatever ground the prosecution consents to. And to take a step back too, it's important to remember here, not only are prosecutors officers of the court, but here the prosecutor's office voluntarily reopened an reinvestigation here twice and really dug into the facts 2 times. And that differentiates this case even from Green, where the prosecutor's office was affirmatively ordered to reinvestigate. And I think that record is significant, and it suggests there's nothing going on here to suggest that the prosecutors were out there to thwart Mr. Rosario's recovery. In fact, what we had here is Justice Torres doing a deep dive into the record, looking at everything, including claims for newly discovered evidence and actual innocence that had been repeatedly litigated in multiple courts, both federal and state, and had been repeatedly rejected. And I should just clarify that there has been no determination of actual innocence, despite Mr. Rosario repeatedly raising that claim. It has never been accepted. If Mr. Rosario thinks that there's an error, he can go. His forum is in the Supreme Court, and we know that if Mr. Rosario's situation were changed, there are reliefs. We know there is relief. For example, we know from the Court of Appeals decision in the Long case, that was a case where someone similarly situated to Mr. Rosario moved to amend to add an enumerated ground, and the court affirmatively granted that relief. So someone in Mr. Rosario's position who is affirmatively able to evidence an enumerated ground is within the power to do so. The problem here is that although he's repeatedly litigated those claims, courts have repeatedly found that they are unsubstantiated.
Any further questions from the bench? All right, thank you, Ms. Olson. Ms. Green, you have 2 minutes.
Your Honor, the notion that Judge Torres did a deep dive of the record in this case is completely incorrect, because the DA's office did not disclose the entirety of the record that led to the vacatur. Nonetheless, this court can remedy that and actually look at the record in this case. And Baba Ali, which is binding Court of Appeals precedent, tells us that this court has the authority to look at the record and see what the actual basis for the vacatur was. I'm
confused about something. If you could just clear it up for me. You said that the DA's office did not reveal to Judge Torres what was the true reason that they were consenting. That he didn't reveal to them. The DA's office did not reveal to the judge this newly discovered evidence. How would, if we were to employ what you're suggesting, how would we then be able to examine the record before Judge Torres and see the evidence that was not revealed to him?
Your Honor, the evidence that was not revealed to Judge Torres is in the record in this case. It's in the form of 3 interviews, including of the victim's immediate family, who stated that there was that.
Well, how did it get into the record if it wasn't given to Judge Torres?
The reason that it wasn't given to Judge Torres is because it was suppressed. It cannot be the rule that an innocent person cannot come into the court of claims.
So the question is one of procedure, I believe. If it wasn't in the record before Judge Torres, then why would it now be in the record on appeal?
It is in the record in the Court of Claims case. He has put this evidence.
I'm sorry, the Court of Claims case.
Yes. All of this evidence is in the record in this case. And in fact, the judge in this case was considering that evidence until the 4th Department decision came down in Genty. But it cannot, again,
it cannot be about the interviews of some individuals who were allegedly at a birthday party or a party somewhere out of state. Is that what you're referring to?
No, Your Honor. The victim's immediate family, in interviews with the district attorney's office, came forward and said that Mr. Collazo, at the time of his murder, was afraid for his life because he knew he was going to be killed in retaliation. The evidence against Mr. Rosario at the trial in this case, and the prosecution's theory, was that Mr. Rosario, a complete stranger to Mr. Collazo, was killed. Mr. Collazo was killed in a completely random encounter.
But I thought that was before Judge Torres. I thought there was something about Collazo recanting. Wasn't that before Judge Torres?
No, Your Honor. The evidence from Guanica Collazo, Alexis Gonzalez, and Michael Sanchez that Collazo had said he knew he was going to die and armed himself with a gun was not before the criminal court. That was in possession of the DA's office, and it directly contradicted the theory against Mr. Rosario at trial.
All the more reason I would think he would go back before Judge Torres and ask that he vacate.
Okay, I thank you very much for the arguments on both sides. We will take another look at this. It was very helpful, and have a nice afternoon. Thank you both. The next case is Pons versus Adrenas Partners. Appellant, you may begin.
May it please the court, I'm Ken Sussman and I represent the plaintiff appellant. This was a scam investment scheme in which plaintiffs lost millions of dollars. We brought a derivative claim for an accounting to determine the proper amount of distributions to the partners and require return of the excess. The lower court dismissed the accounting claim for failure to name required parties. Firstly, it ruled that the failure to name the estate of Daniel Friedlander was fatal to our accounting claim.
Yes, I mean, you did in fact name the estate, but don't you have to do more than name an estate? An estate, you can't really sue an estate. Don't you have to get somebody appointed as by the surrogates court to represent the estate? Somebody to be
well, for purposes of the motion to dismiss, we did name the estate as a party and did commence proceedings to get an administrator named.
Where in the surrogates court you try to get an administrator? Are you?
We did.
You, but have you gotten an administrator yet?
We have not. But the second point with respect to the estate is the estate was not a partner in the partnership. So it was an error to even suggest that it was a necessary party. The state, Daniel Friedlander was not a limited partner. There was a corporate general partner, distinct from the estate of Daniel Friedlander. So he is not a party to the accounting at all. Defendant argues that since he was the member of the corporate entity, he should be named, but that just ignores the reality of the corporate existence. So first of all, he was named, and second of all, he was not a partner. The second party that the court claimed should have been named was a former limited partner by the name of Charpentier. He had assigned all right, title, and interest to his partnership interest to another one of the plaintiffs, and the plaintiff, Yannick Pons, brought the derivative claim in his own interest and the interest that he acquired from Mr. Charpentier.
Mr. Sussman, I'm going to tell you the cause of action I wanted to ask you about personally. So the fraudulent conveyance cause of action. I mean, in your complaint, you put a couple sentences in the fraudulent conveyance claim. You did not mention anything about the debtor and creditors law, whether you have a claim under which section of the debtors creditors law. I mean, you acted like you didn't even know this was a statutory cause of action. How can that possibly be sustained under the, the very, very, very limited allegations that you've made in your complaint?
Well, we do make the allegations that there was adequate consideration. We do make the allegation that the defendant knew and had reason to know of the fraud. And we do have the allegation that specifically this plaintiff knew that this would render the company with insufficient capital. And we think that is sufficient to state a fraudulent conveyance claim.
Well, okay. Any other questions anybody has? Anything else you need to say now, or you want to wait till your rebuttal?
Well, I would say that with respect to the unjust enrichment claim, that was dismissed as duplicative of our breach of contract claim. Our breach of contract claim was dismissed because we didn't have a copy of the partnership agreement and couldn't specify the exact terms of the contract that were breached. Based on that inability to plead the breach of contract and identify the specific terms of the contract, we don't think our unjust enrichment claim is duplicative. The other point I would make is I'll save the rest of my time for rebuttal. That's the only point I'd like to make now.
Okay, thank you very much. Can I hear from other respondent, please?
Thank you very much, Your Honor. Good afternoon, and may it please the court. My name is Alan Efron, and I represent the defendant's respondents, Zandra Nunnerly, Inc., and its individual principal. Let me start by addressing the question that Justice Kapnick started out with, focusing on the fraudulent conveyance claim. At the risk of freezing my connection, Justice Kapnick is exactly right. Nowhere in the amended complaint is the debtor-creditor law even mentioned, much less any specific provision relied upon. Moreover, the amended complaint does not distinguish between fraudulent conveyance claims based on actual intent and those based on constructive fraud. As a result, the commercial part did not distinguish between those claims. It did not apply the heightened particularity standard under CPLR 3016B to the actual intent claims, but not the constructive fraudulent claims, as is the settled law of this court, but simply had to go along with the plaintiff's jumbling of all these claims together. In the end, plaintiffs only simply allege that they sufficiently pleaded for so-called badges of fraud, which are typically associated only with fraudulent conveyance claims based on actual intent, and therefore are subject to the heightened particularity standard of 3016B. Nevertheless, the court properly held that these allegations do not meet even the ordinary notice standard, much less any heightened particularity standard. Plaintiffs have sued SNI based solely on its redemption of funds from a limited partnership 8 months before the fraud was discovered. Neither SNI nor its individual principal, however, is alleged to have acted in any way to further the fraud or to have known about the fraud in any way. I'll start first with the arguments made by plaintiffs on appeal do not undermine the decision of the commercial part dismissing the amended complaint. My friend did not explain refer to the second party that the commercial part held was a necessary party who is not joined in the amended complaint, and that is a former limited partner named Gilles Charpentier.
Isn't he named as a plaintiff? Isn't his name in the caption?
Well, at one point, that's a real mystery, Your Honor. At one point, he was named as a caption, but then plaintiff's counsel announced that, well, they didn't represent Charpentier after all, and he was not actually appearing as a plaintiff at all. But apparently at that point, they were unable to extract his name from the caption, according to the clerk of the court. So he sort of continues as a ghost in this case, even though he's not among the plaintiffs, and he has never been named in the amended complaint as a defendant.
But isn't there an allegation that he assigned his rights to some of the other plaintiffs? So what do we need him in there in the first place?
That's correct, Your Honor. But as a New York court held over a century ago, even where a partner assigns his or her partnership interest, that partner remains a necessary party to any partnership accounting. Unless the assigning partner is joined, he or she could later attack the validity of the assignment itself or the results of the accounting. Joinder is especially appropriate here, where Gilles Charpentier did not assign his interest, as plaintiffs acknowledged, until after they commenced this lawsuit. Moving on to the estate of Daniel Friedlander. The fact that plaintiffs have attempted, apparently, to have an administrator or representative appointed in the surrogate's court is simply not sufficient. It is very clear that an estate cannot be joined, cannot even be adequately named as a party, unless and until an administrator or representative is actually appointed to represent the estate. That has not happened here.
Well, they've at least made an application at this point, apparently. Is that correct?
That is, well, we don't know, according to Mr. Sussman's representation, there's nothing in the record about that. But unless and until that actually happens, the estate cannot be joined because the estate doesn't really exist. There's not a party capable of being sued.
I get it.
It's actually accomplished.
So the last thing, if you could just take 30 seconds, what about the unjust enrichment? Because the court dismissed that also, and he wants to put that back in as well. Is that properly pled?
It is not properly pled, Your Honor. A claim of unjust enrichment may be asserted as an alternative to a claim of breach of contract only if there is a bona fide dispute as to the existence of a valid and enforceable agreement, or the agreement does not cover the dispute. Here, plaintiffs do not dispute the existence, validity, or enforceability of the party's written partnership agreement, or whether it covers the subject of partner redemptions. As a result, they have not properly pleaded a claim of unjust enrichment, even in the alternative.
Okay. Mr. Sussman, you have 1 minute on rebuttal. Thank you, Mr. Effin.
Thank you.
You're muted, Mr. Sussman.
Pardon me. With respect to the estate of Friedlander and the accounting claim, again, he was not a partner. He's not a necessary party. That was just a pure error by the court. With respect to Mr. Charpentier, the century-old case by...
Have you filed an application for an appointment of a representative?
Yes, we did.
When did you do that?
It was done, I don't really recall, Your Honor, because another firm was handling that, but it was done before the motion to dismiss was argued.
Has it been ruled on?
And it hasn't. There's been a dispute with the estate. The estate certainly wouldn't consent to it, and the lower court, at the motion to dismiss, did state that it would give us additional time to make the estate a party. But again, it wasn't a partner. With respect to Mr. Charpentier, counsel cites a century-old case from the Albany Supreme Court, Pine Cliff, which has never been cited by another New York case, is not the law. That was a case involving cutting timber in a general partnership. And there's absolutely no reason why all the former limited partners of a limited partnership would be necessary parties, particularly where all right, title, and interest to his partnership interest was assigned to Mr. Bonds, and there's absolutely no reason for a former limited partner to be named, and no case cited other than a 100-year-old case and an Alabama case to support that, Your Honor.
All right. Thank you. Thank you both very much. Have a nice afternoon.
Thank you.
The next case is P62 LLC. We're ready for the appellant to begin.
Good afternoon, Your Honors. Kenneth Philbin for the appellant. We are seeking to reverse Supreme Court's order denying a motion for summary judgment. Your Honors, this case is a clear-cut example of exactly what summary judgment is for. The parties completed all discovery. The case was certified ready for trial, but there was nothing to be tried. All of the facts and evidence in the complete record, which includes competing 19A statements, multiple sworn affidavits.
This is Judge Owing. You said there's nothing to be tried. I thought that the way I saw the oral argument play out with respect to plaintiff's tenant's breach of contract claim against your client, the landlord, right? Your client's the landlord, your client's the property owner. It had to do with the options and the kiosk and all that kind of in terms of you did. The claim is that the tenant is saying you never gave me notice that you were going to do these kiosks, they're valuable. So that, and it came down to the property or your client's argument saying, well, you're in default of the payments, right? So therefore, you're not entitled to notice, and the options never came into being at that point, correct? I mean,
That's absolutely correct,
right.
Your Honor.
So here's where the breach of contract question comes in. They're arguing that they didn't breach the contract, that they gave you payment, that it was somehow, it couldn't be negotiated, that it was stale, that you didn't, and all that kind of stuff going back and forth. Isn't that enough for a factual issue as to whether or not there's a breach there?
But Your Honor, none of what you just described is in dispute. The facts are not in dispute. The only things that are to be determined is what does a court make in terms of the legal determinations on those facts. They admit that they received it, they didn't pay rent due under their prior leases.
$54,000 is what I couldn't understand. I mean, it's 50. I had to read that twice or 3 times. It's 54,000. It's not 54 million, right? It's 54,000, right? That's the rest of the owed, right? And the thing that I didn't understand, and this was what Justice Ostrager was pointing, is that why did you get your check so late, 7 months or 6 months late, right? They gave you the check 6 months after they got it.
That's correct. They received the checks on October 27th, 2014. They didn't deliver them to us until June 5th, 2015. And as we say in our brief, the reasons for that are evident in the record. What happened in that gap? They admit in October 2014, they owed us $55,000. In October 2014, they got checks payable to both parties, which they testified were specifically earmarked to pay rent to us. Again, in October.
Well, it had your name on it, right?
But they didn't give them to us until 7 months later. And what were they doing during that 7 months? They were trying to negotiate a deal to only give us 25. And then it was only to give us 40. And only when the parties were unable to come to an agreement on some lesser amount than what we were owed, 7 months later, they say, okay, fine, here's the checks. Well, by that point, checks that are more than 6 months old don't have to be honored by banks. HSBC told us they would not, in fact, take them.
Is that somewhere in the record that HSBC declined to honor the check because it was stale? I forget. I didn't get to see that.
It's set forth in email communications from the landlord on July 7th, roughly a month after the checks were delivered. We emailed Mr. Cohn, let him know the bank won't take the checks because they're stale, and we're sending them back to you. And did he respond with an objection? Did he respond and say that's ridiculous? The bank has to take them? No, he said, I apologize for the inconvenience. We'll get you new checks.
So counsel, this is Judge Weber. Why would all of this not constitute issues of fact that would have to be decided and could not now be just adjudicated in a motion for summary judgment?
Because all the facts that I just described are set forth in the record. What is there for a witness to testify about as to whether they have satisfied the kiosk conditions? The evidence in the record already demonstrates that they did not. And it's by their own fault that they delayed in delivering those checks.
Their only claim remaining against you is the breach of contract claim in this case?
Correct. All the case was initially commenced in 2018. They initially sought injunctive relief. That was withdrawn. And as the litigations progressed, their claims were narrowed to solely seek the damages because the option contract, of course, expired in 2020.
Right.
So the only years at issue are 2016 to 2020. And there's no dispute by anyone that during that time, that money is still out there. And as you said, Justice Ong, we're not talking a huge amount of money. They put in affidavits talking about all their successful businesses, their 16 restaurants, and all these other things. They have ample opportunity to have paid that money if they wanted to preserve their kiosk option.
What about the affirmative defenses? Aren't some of those still left into this case? Third-party claims and affirmative defenses?
Well, all the affirmative defenses, essentially everything is wrapped into, did they have an option or not? So some of the defenses are based on payment and acceptance, based on this argument that their mere tender of the checks constituted payment of the debt, even though the checks were never negotiated and returned to them. Likewise, all of the defenses, as illustrated by their briefs, which they treat, their defenses in a cursory bullet point fashion, it's all wrapped up in the fundamental issue, and that is, did they satisfy the kiosk options to spring into existence their option? The record shows that's irrefutably no. And then this argument that for somehow the agreement was modified, despite the fact that it could not be modified except in writing, there's no writing, and the only unequivocal conduct they can point to indicate it is that we accepted some partial payments and we didn't sue them.
Okay, I'm going to ask you if you can hold off with any other comments till your rebuttal.
Sure.
And hear from Mr. Alonso, please. Thank you. You're muted, Mr. Alonso.
Yes, someone muted me beforehand. Thank you, Your Honor. I know you understand the facts, but keep in mind on an overarching point here, there is a logical point. My client closed its restaurant because Brookfield at that time wanted to compete, wanted to renovate its mall and inside and out, which faces the Statue of Liberty, extremely valuable property. And within that, they wanted to compete with what was soon to be the Oculus and World Trade Center. So they asked us to leave.
Justice Owen, you're muted. If you,
Sorry.
Mr.
Alonso, I understand what you're saying. This was a valuable piece of area that you want to put kiosks in. But let's get to the other part about whether or not you were even entitled to have that option. Did it come into existence? And that goes down to whether or not you were in default, right? And my question is, you served them with a check 6-7 months after you got it. They come to you and say, or the landlord says to you, to your client, my bank dishonored it. Did you go back and say, well, no, that's impossible. Why would they dishonor it? I mean, did you? Instead, I read from the record, unless I'm reading it wrong, from the oral argument, your client basically said, I'm really sorry. Let me go and try to work out something with the city of New York. And then somewhere someone says, well, why don't you have it directly sent to us and whatever. All this stuff goes back and forth, but it still doesn't, there's still nothing that showed me from this record that when the landlord says to your client, the check was not cashed because the bank it's stale. There's nothing, a factual issue there that was a sort of a pretext, that it was just all made up and they just want to hold you in default.
Well, number one, bear in mind that at that time there was no urgency. They had never even told us they made a decision that they were even thinking about putting kiosks back, which is the fundamental thing they must do, is tell us they've made a decision. And then number two, they got to go to the city and get a permit to have outdoor facilities, the little kiosks.
But isn't that all dependent on whether or not you're in default before they had to even give you any notice?
If you go by them, then we were always in default. There was no point in even having an agreement because we would have been in default from the inception. Number one. Number two, they were taking payments, which, Your Honor, I'm not going to go into the nuances with you of landlord-tenant law, but the reality is that default isn't always a default. It might require a new predicate notice, acceptance of payments on a commercial tenant. There's a lot of things
that has nothing to do with the options. Options are separate and apart from rent payments.
But the option merely says you have not to be in default, and bearing in mind that that's only at the back end. When it comes time that we have 30 days, we have to cure everything. And we never became aware of that because the only way we found out was when one of the principals was walking across the plaza and they erected a new kiosk in the spot that should have been our spot.
You had the check for 7 months. Why didn't you give him the check in a more timely fashion?
They were negotiating an amount because it was more than one check and the check was for more. And by NYBDC rules, if I don't know if anyone had any case like that, but and this may happen again through the pandemic, when they give out those grants, they make them payable to the tenant and the landlord to make sure that the landlord gets his rent. But they weren't exact amounts because we had been paying, which resulted in a lower amount. So their acceptance of rent during this period of time certainly didn't indicate that it was a default. They signed on to this application to get the rent. They endorsed the check. And by the way, they say, oh, that's not proper payment, a double made out check, and it's illegal. Well, first of all, on a motion for summary judgment, you need to have evidence. More so now under the new rules that are required to be admissible. All they have is one person saying, here's what the bank said. There's no deposit slip. There's no advice from the bank. There's no email from the bank. It's two people in Brookfield talking to each other, which is inadmissible.
I'm sorry, you're saying that the bank said that they would not accept a double endorsed check, or that you're saying
the bank has never said that.
Who said they would not accept a double endorsed?
Somebody at Brookfield to somebody else at Brookfield, and then they told us. So we said in good faith, because we didn't know there was any urgency. We didn't know that this was a default situation. It was just
Alonzo, Mr. Alonzo, I gotta say, for $54,000, we're gonna have such a big fight for $54,000. Somebody could just cut a check for $54,000, and you wouldn't have this client as a problem at this point, don't you think?
I understand, but
I mean, did they hire you from the get-go?
No,
I mean, that's their problem. They didn't hire you from the get-go.
Well, thank you for the ringing endorsement, but that doesn't solve my problem because you play the hand you're dealt. And my clients often, and not this one, I mean all of them, if they didn't, this was a tortuous agreement because there's no way to know. The option requires, if you read the last part of the option, they're supposed to tell us when they make a decision to do this project. And then, even then, they still have to get permits from the city. And only then do we have 30 days to claim the option and make payment. There was no urgency. There was nothing that ever would indicate until 7 months into it when they said, we'll take a lower amount and gave us an agreement that said, but we want you to waive the option. If nothing else, that might show a trier of fact that the intent was that the option was still in existence at the time.
Okay.
I accept
Please
that
finish up.
It wasn't clean, but I do know that in a situation, there's a lot of issues of intent, there's a lot of issues of practice, and there's a lot of issues which might go to frustration of our attempts to actually do this. And it's not $54,000. It's an extraordinarily valuable and unique right. There is only one spot like that on earth.
Okay, thank you. You have 2 minutes for rebuttal.
Thank you, Your Honor. I'd like to focus on one of the things Mr. Alonzo seems to be arguing. What do we have here? We're talking about KIAS condition number 4, which states that in order for the P62 to have an option, it cannot be in default of one of its prior contracts with us. What Mr. Alonzo is contending is that the tenant essentially has a double option. It has the option to the option. So once it can make the decision whether or not to pay us.
Mr. Phil, Mr. Judge Wong, I have one quick question. Mr. Alonzo alerted to it at the very end of his argument. And that, why is it that if you really truly believe there was a default and the option never sprung into being, that you still required them to waive the option in that agreement later on? He was mentioning about an agreement later on.
At the time these negotiations were taking place in 2014 and 2015, the plaza was closed.
Right.
It was under construction. It didn't reopen until 2016.
Right.
So if they had cured, they would have been able to enjoy option rights in the future.
At that point, I gather the position is that you thought because of the check issue and everything that they were in default. But if that were actually the case, if you stood on that, you didn't need to put in the waiver language of the option, right? I mean,
but the parties were trying to come to a resolution. They were offering less than 100 cents on the dollar. And we said, well, if we're going to take less than we're owed, we want this option to be over with. They wouldn't go along with that.
They gotta, you know what? These folks, these sophisticated business people, it's getting to a point where they're gonna have to videotape these guys in the discussion.
And if the court looks to the fundamental provision, paragraph 1B, it actually contemplates in a clarification language that it's about, are the conditions satisfied if the plaza is closed and reopens in future years? and the conditions are satisfied in that subsequent year, then they shall have the option. That's right in the first sentence of 1B in a parenthetical towards the end of the sentence. So they were trying to cure their default without paying all the money. We said, well, if we're not getting all the money, we don't want this to continue doing business. If they had paid the full amount, then the conditions would have been satisfied and none of us would be here right now.
All right. Well, thank you for being here right now and that led into that, and have a nice rest of the afternoon.
Thank you all very much.
Thank you.
Have a good day, Mark.
Take another look. The next case is Jaffa versus City of New York.
May it please the court, Your Honor. This is Mikhail Schenker on behalf of Appellant Jack Jaffa and Associates. The purpose of this appeal is to challenge the determination of Justice Recauer in the trial court concerning two ECB policies that the lower court upheld. The first policy is with regard to refusal to reschedule hearings that fall on religious holidays. And the second policy concerns the requirement of original wet ink signature on authorization forms submitted by that have to be submitted by a registered representative.
So counsel, this is Judge Owing. I got a question on the original signature issue that you raised. That doesn't require your client. I mean, the person that your client's representing, that doesn't mean that person actually has to appear before the hearing officer and sign it. That just means the original signature means that the document that's being presented to the hearing officer has to bear a original signature and not a photocopy. Is that correct?
That is correct, Your Honor.
Okay. I just want to make sure that the person doesn't have to appear and sign it, because that's kind of like, why are we doing that? Okay.
No, you have to submit the original signature, right, and the clerk takes this original signature, makes a photocopy, keeps the photocopy, gives you back the original signature.
Got it. Right.
So, counsel, the question.
Okay, I got it.
The question is, how is this arbitrary and capricious?
Well, it is arbitrary and capricious because very often my clients are hired at the very last moment before the hearing, and obtaining the actual wet ink signature that has to be either mailed or hand delivered to their office. It creates sometimes very often it creates a mechanical problem of getting it in time before the hearing, with the result that it is almost impossible to achieve, simply because.
But I thought that the argument that their position was that there had been, I guess, irregularities, forgeries, etc., and so they wanted to ensure by imposing this requirement, they wanted to ensure that there would not be these irregularities, these forgeries.
Well, if they did so through satisfying the formalities of the City Administrative Proceedings Act, they would have had to present all of these issues at a public hearing and then adopted a formal rule, which they haven't. So there is no way for us, there is no record for us to base it off and determine whether or not their rationale is valid. And I would argue that it is quite.
Counsel, this is Judge Owing. I just want to touch on what Justice Wedler said. In the record here, correct me if I'm wrong, but wasn't there a situation that you represented some individuals that later on disclaimed that you were authorized to represent them, and oath had to vacate all those decisions and retry those matters? Or am I reading something wrong?
There was an allegation to that effect. You're reading.
Well, no, is it accurate or not? I mean, the claim is that they had to vacate several decisions.
But what we were saying is that during the proceeding, we served a FOIL request on oath, and we requested any proof that they ever disciplined a registered representative for just this. They came out with no documents saying they never disciplined anyone. Yet.
The disciplining and actually vacating orders are different. I mean, they may not have disciplined you, but they may have vacated the orders. So, I mean, that doesn't prove anything. I mean, it doesn't say anything.
Counselor, with respect to your other issue, the issue of scheduling hearings on religious holidays, my reading of the materials that they gave you the right to tell them what days you were not available after the first adjournment. So by doing that, you could avoid being scheduled on a religious holiday.
If initially we were the ones who did the rescheduling, yes. But very often what happens is that the client who gets the summons, the property owner, reschedules on their own. Then when they cannot reschedule any longer, they hire our client to represent them. And very often, I cannot say often, but it happens that rescheduled date that someone obtained prior to hiring us then happens to fall on a religious holiday. And then
religious holiday for whom? For you or for the client?
It can be both, but it's usually for us.
Aren't you entitled to in the first instance give them dates that you're not available, to ask them please don't adjourn it to these dates or reschedule to these dates?
Not if it has already been rescheduled once. If
so in other words, the client has scheduled a date, and now they're coming to you after that date to schedule another date, and because the rule is that you can't select that second date, it may fall on a holiday and there's nothing you can do about it. Is that correct?
Correct.
Okay, Mr. Schenker, you've asked for a minute in rebuttal, so I'm going to stop you here and let Ms. Campbell go. You'll have a minute in rebuttal, okay? Thank you very much.
Good afternoon, Your Honor. Yes, good afternoon. Amy McCampbell on behalf of the respondents, the City of New York, and Oath. Your Honor, starting with the original signature policy, first of all, we believe that the arbitrary and capricious challenge has not been preserved because it was not presented in the appellate brief. But in any event, this policy clearly has a rational basis. We have testimony from the Oath Chief Hearing Clerk, Maria Marciano, who explained the reason why this policy was implemented to deter fraud, the instances of unauthorized representation, including instances with Jaffa.
And the thing is, I don't think it's particularly onerous to present an original signature. It's not like you have to bring the respondent in to actually sign in front of the hearing officer. You just have to bring in an original signature. I don't see how particularly onerous that is. It's not like they're asking you to get a notary, because notary, I can understand that's putting a lot of burden on the property owner, because they got to go find a notary, you got to pay for a notary. This is merely asking for an original signature. And it's not, and in terms of the online and mailing, you don't have any concerns about misrepresentations or no unauthorized representation, because that's by mail and online, and you're clicking stuff and you're authorizing that. So that's easy in that sense, right?
That's correct, Your Honor.
But your adversary argues that there was no public hearing, no discussion, and that they were unable to actually present any evidence that it was not rational because the FOIA request was denied.
Well, Your Honor, I think that you're referring to the ultra vires claim, which Jaffa has alleged, which argues that this policy needed to be promulgated as a formal rule. But there's 2 Court of Appeals cases directly on point that recognize that when you have an agency policy that merely specifies the method of proof to show compliance with an existing agency rule, that doesn't require formal rulemaking. Those are the Elcor Health Service case and the Cubas versus Martinez case. Those are the cases that we cited in our brief, and Jaffa has made no attempt to distinguish them, much less even acknowledge them. So for that reason, formal rulemaking was not required here. And to address the rescheduling point, with respect, the scheduling issues that Jaffa is complaining of are not attributable to Oath's policies. Again, it's undisputed that Oath allows all respondents 1 reschedule as of right before the first hearing and 1 reschedule as of right after the first default. So even in cases when Jaffa's clients procrastinate and don't contact Jaffa until right before the first rescheduled hearing, which is not Oath's responsibility, but even in those cases, the cases can go to default and then they get a guaranteed reinstatement and reschedule after the first default, and they can specify dates of unavailability. Jaffa has never alleged that Oath has failed to honor those requested dates of unavailability.
But aren't you putting an additional layer there, because then they have to move to open the default? So aren't you adding? I mean, there's additional work for them to do now. They have to move
It
to,
is a little more effort. Yes, Your Honor, but the oath rules specify that on the first default, if they make a request in time, they get a guaranteed reschedule. So the rules are fair. They allow everyone ample opportunity to schedule around religious obligation or any other personal obligations that people might have. And these are reasonable rules that Oath has implemented in order to deal with its massive caseload. The Jaffa's reply brief points out that its clients have a tendency to procrastinate. It's for that reason that Oath needs to set some reasonable limits on the amount of as of right reschedules. And moreover,
this is not only Jaffa's clients, these are other clients as well. Is that correct? I mean, these rules they're not specific to Jaffa clients. They're as to everyone. Is that correct?
They do apply to all Oath respondents, and they are longstanding Oath rules. And again, they're implemented to allow everyone fair opportunity to reschedule their hearings while also dealing with the massive caseload that Oath handles. And moreover, the cases that the lower court relied upon in granting the motion to dismiss here, they show that when you have a law that is neutral in object and application, just like the scheduling rules, there's no First Amendment violation. That's the Employment Division versus Smith case and the Catholic Charities case.
How many cases do you have a year? How many? You said you have a massive caseload. How many a year?
300,000.
The record shows that Oath handles about 800,000 summons a year.
Oops.
And average number of over 1,000 hearings a day.
Thank you.
Okay. Thank you very much. Mr. Shanker, you have 1 minute.
I would like to quickly point out that the lower court misinterpreted Catholic Charities of Diocese. The idea that if there is a neutral law that bears only incidental burden on religious observance would shield the law is wrong. The court in Catholic Charities did an unreasonable interference analysis where it considered the interests served by the law, in that case women's rights, and the burden of providing insurance.
Counsel, this is Judge Owen. Are you disputing that with your first default that you get an automatic new date? All you have to do is kindly come in and say, hey, please excuse my default. I need another date, and you get it.
But for our religious freedom analysis, it actually cuts the other way.
But even so, even if your client, not your client, but your client represents somebody, that first date is picked by the property owner. It's not a good date for you. It falls on whatever date that's not convenient for you. So the property owner gets defaulted. So then now the default date. So you go in immediately, like, I don't know, whatever the timeline it is, like 30 days, probably within 30 days to go in. So you go in, your client goes in and say, excuse the property owner's default. They give you another date.
But it puts us as professionals in the place of second-grade citizens, because now we have to explain to the client that we defaulted because of our religious observance.
You defaulted also because you yourself argue that your clients tend to procrastinate. So if actually they had come to you right away, you may not have had that issue, right?
Yes, but that's not our religious
That's not the reality, and that's not how it works. All right.
What I would like just to point out the last thing.
Half a minute.
The fact that what Oath says, it has a huge caseload and it cannot accommodate and reschedule for religious observance, but then it forces us to go into default, then have to tell our client that we've defaulted, and then no problem, you can reschedule without a problem. It doesn't make sense.
Okay. I think we got your point. Thank you very much for the argument. We appreciate both of you coming in this afternoon, or speaking to us this afternoon. Okay, the next case is Campbell versus St. Barnabas. The appellant, Mr. Buckley.
Good afternoon, Your Honors. I'm William Buckley for St. Barnabas Hospital. At the beginning of the trial in this case, during opening statements, the counsel for plaintiff stated, I am going to prove that somebody from St. Barnabas moved a stool and put it right next to the plaintiff as she was about to turn around at the windows. Counsel repeated that statement during closing arguments. So I was looking during preparation of the post-trial motion, where exactly in the transcript does it say that? There's no place that says that. There's also a statement in the response to that motion that I proved that I had a client who was tripped basically by someone putting a stool down next to her. That's not there. That statement is repeated, though, in the arguments that plaintiff puts before the court in this appeal. There's no proof that that happened. In fact, Ms. Hicks, who's the only person who could testify about stools being present in the room before the accident, said in her deposition that was read to the jury, before plaintiff, this is at page
So your argument now, you're focusing your argument now on the insufficiency of plaintiff's proof. Is that correct?
Correct, Your Honor, that the case should be dismissed, all right?
On insufficiency.
Insufficiency, that plaintiff didn't make a prima facie case.
If you were to move off of that argument,
Okay.
what else would you be arguing?
Okay, I would also be arguing that the verdict that the jury found Ms. Campbell was negligent, but her negligence did not become a proximate cause of her injuries, is against the weight of the evidence.
Well, you're really arguing that it's an inconsistent verdict.
Well,
and inconsistency, as you well know, has to be brought up to the court prior to the discharge of the jury.
Very much so, Your Honor. I'm very aware of that, and that's why I didn't argue that this verdict is inconsistent.
Oh, you called it something else.
Well, I called it something else because I looked at cases like McDonald, Decisori, and Fisk. In McDonald, somebody was not looking where they were going and fell in the space between the Long Island Railroad train and the platform. That was a verdict that was against the weight of the evidence. In Decisori, the plaintiff went to a staircase
well, there is
on the
evidence
telephone.
Here that this stool was in one place when the woman entered the plaintiff entered the physical therapy area, and that somehow it was moved to another area where she tripped over it.
That's correct. However, the plaintiff's witness is Ms. Hicks, who says, before she walked over there, I seen this therapist. I'm not sure which one it was, but I was quite sure I seen them put it down. But I'm saying I don't know exactly where they put it. Ms. Hicks is acknowledging the fact that the stool was moved before plaintiff left Ms. Hicks and went over to the windows to set down the purses and the coats. Now, plaintiff can, of course, make a case if she can establish that there was a hazard in the room, but there's no proof of any kind of a hazard. All we have proof of is the fact that there's a stool in the room.
Well,
Plaintiff,
I mean, this is a rehab facility. Am I correct?
Yes.
And
yes,
so a stool that rehab patients, may be able to trip over is somewhat hazardous, and isn't that at least an issue of fact for a jury to determine?
Yes, Your Honor, that would be a fact that they could determine that it's something you could trip over. But the fact is, there's no proof of the fact that it was placed in a dangerous spot where people are going to walk. People can trip over a
She was walking and she fell over the stool, so that's where it was. I mean, I don't understand why that's not at least circumstantial evidence that somebody. I mean, even if no one saw, and apparently nobody saw who put the stool exactly where they put the stool. And I can understand that happening because there's a lot of different therapists and there's a lot of different patients. And then there's patients who have helpers. Like, I mean, this poor Miss Campbell was actually a health aide for Miss Hicks. If I understand.
But we could say that the plaintiff.
Also, I'm sorry, counsel. I also thought that there was testimony that the stool would not be placed under. I don't know, under something.
A table, like
it was necessary for it to be out so that individuals would be able, those individuals who, couldn't get up on the table, get up on the unicycle, I think is what they said, would be able to alight from the stool onto the unicycle. So it's not going to be under any type of a table. It's going to be out.
Right. The testimony by Mr. Brandwin, the therapist, was that it was too big to put it under the table because people had to sit at that table. So where is it put? It's near the bicycles. There's no testimony from anybody except Mr. Brandon about bicycles being in that room.
And there's no testimony as to the height of the stool.
Oh, yes, there is, Your Honor.
Testimony is a few inches, but
Your Honor, if you look at the transcript of the deposition of Ms. Hicks, she was actually asked, how high was that stool? She goes, and the attorney said, about this high? Now, that's not in the record, but the attorney says, oh, about 2 feet. So it was 2 feet high. So that's in the record that this is a big object, all right, stored near bicycles, all right? And the point is, Ms. Hicks did testify that the plaintiff didn't walk over to the windows to drop the pocketbooks and coats, but went to a chair that was near the corner of the room. That's
I
at page
keep
233.
focusing on the sufficiency or the weight of evidence. Now that are you abandoning your other arguments here?
Of course not, Your Honor. Oh, no, no, Your Honor. I just was responding to questions I thought from the court. Going
So
on
what
to the
about
fact
the
that
issue as to the lack of a curative or the charge as to testimony as to insurance?
Yeah, Your Honor, with that, what's particularly difficult in this case, why we had to have a mistrial or a curative instruction, is counsel for St. Barnabas, as soon as that word insurance company came up, asked for the curative instruction. The court ignored that and simply said to the witness, oh, do you know the answer to that question? And encourages the witness to continue. In other words, they're implying to the jury, you're not going to hurt St. Barnabas, you're going to hurt an insurance company if you find in favor of the plaintiff. And that's why that's
mentioned again.
Pardon me?
Was the word insurance used a second time?
He said outside agency, all right, in response to clarifying the question. I think maybe the doctor was tipped off, get off that word insurance, all right, but use that. And it did come up again, of course, during the charging conference when St. Barnabas asked for a mistrial. You can ask for a mistrial anytime up to the time the jury gets the case. As far as a mistrial here goes, the court said, well, I could give a curative instruction now. The court, St. Barnabas's counsel said, Your Honor, right now it would simply refocus the jury on that issue.
So does that mean that you're waiving that issue of the use of the word insurance?
Absolutely not, Your Honor. We're asking for a mistrial. That's why we asked this court to send this back to the Supreme Court to have a trial, because that was not fair. St. Barnabas, in fact, is not insured. That's why the attorneys, that's not in the record. But the attorney said that's not accurate when you say an insurance company hired a physician to perform an IME. In the short time, should I go to the damages, or does the court
You
have
know
that
what?
argument?
Can you save that? Would you
Sure.
be kind enough to save that?
Exactly,
for
Your Honor,
rebuttal?
yeah.
We had a lot of questions,
Right,
so
I
I know
understand.
you sort of stole your time away from me, but that's what we
Thanks.
needed to know.
Okay.
Mr. Torto.
Thank you, Your Honor. My name is Thomas Torto, and I represent the plaintiff. First, we submit that when you view the evidence that was presented at the trial in the light that's most favorable to the plaintiff, the conclusion is inescapable that the trial court properly determined that there was a reasonable basis from which the jury could conclude that the defendant created a dangerous condition in the occupational therapy room that caused the plaintiff to fall by placing the step stool in an unsafe place where people walked. Contrary to counsel's argument, there was uncontroverted evidence of what happened here, and that was established through the deposition testimony of Ms. Hicks. It's at pages 230 to 240 of the appendix.
Mr. Torto, Ms. Hicks didn't testify in person, did she? They read in her deposition?
That's correct. She was in a wheelchair and could not make it in the court.
Okay, that's what I thought. I just want to confirm.
But she gave detailed testimony, including that she actually witnessed the accident. She saw the therapist aide move the stool. She testified where the stool was actually placed, or at least the jury could reasonably conclude from her testimony as to where the stool was placed and how it contributed to the causing the plaintiff to fall.
But she testified that she saw the stool. So, I mean, doesn't that also cut against you because it goes to open and obvious because she saw the stool? So if she saw the stool, why is it that your client didn't see the stool?
Well, she was sitting down in the wheelchair.
Yes. So you could only
stool.
see it if you were seated and you couldn't see it if you were standing?
No, the stool was only 2 feet high, according to testimony in the record.
I don't understand. It's not like she's seated. I don't know her height, but are you saying that the stool would be eye level if she's seated in the wheelchair?
No, it was not at eye level.
So why is it that she would be able to see it, but your client would not be able to see it?
The client was standing up after she placed the coat in the bag on the windowsill, and when she turned around, the stool was on the floor beneath her knees, and she moved and tripped over it. She didn't
So is
see
the stool right next to her? Is that what you're arguing? Is that she's hanging up her coats or putting the things down, and as she turns, apparently the stool had been put right next to her, so that the first step she's going to take, she's going to go right over the stool?
Yes. That
Really?
was the evidence, and the jury could conclude that that's what happened.
Because Ms.
based on
Hicks
the testimony of
testified.
the effects.
Ms. Hicks' testimony was that she saw the stool after it had been knocked over. Isn't that what she testified to?
No, Judge Mandrielli, she testified that she saw the stool. She saw the aide move the stool.
Yes, but with respect
what did you
to
see? She says, I saw her go in front of the chair and put stuff down. And when she turned, I see her trip over the stool. And then she says, when I first came in, I seen a therapist pick the stool up and hold it. And then he put it down. And then she tests, obviously, that's where they put the stool, i.e. where she fell.
She says, your client says that she began to walk, saying, I'm coming. And then she takes a couple of steps and then she falls forward.
Correct. That stool was placed in the area where she was walking. And that was the argument that was made to the jury. The defense argued that it was an open and obvious condition, but that doesn't excuse the defendant's negligence. It just goes to the plaintiff's comparative.
Well, so now that's a good point, Mr. Torta. So we didn't really ask that, but the jury found that the plaintiff was also negligent in the happening of the accident, but found that it was not a substantial factor. Which how does that happen in this case? And of course, that's compounded, I think, by the fact that the trial judge did not give the standard PJI 236, the comparative fault charge, which kind of usually always give. So I wonder if you could address that issue.
Yeah, we submit that under this court's decisions in Bracker and in Blackman, the jury's finding that plaintiff was negligent, that her negligence was not a substantial factor in causing the fall, was based on a fair interpretation of the evidence, because it was logically possible for the jury to determine that the sole proximate cause of the accident was a negligent placement on a stool by one of the defense employees and not the plaintiff's negligence.
Yeah, but then how is she negligent? Like, how could they otherwise have answered yes to that question?
Right, she wouldn't have been negligent at all.
Well, I think that the key here is that she was distracted. Under the Bracker case and the Blackman case, a similar fact pattern, and the court held that the jury's verdict was consistent because there was testimony that the plaintiff was distracted. The one case was a display like a foot off the floor in a department store, and the plaintiff was negligent for not seeing the display, but her attention was distracted. The same thing here. Under those factual circumstances, it was logically possible to find that she was negligent, but that it wasn't the cause of the accident.
How do you respond, Mr. Torto, to your opposing counsel's arguments regarding the use of the term insurance?
We suggest that the isolated reference by the plaintiff's Dr. Rose, to the word insurance in the context of an IME physician being engaged by an insurance company had no bearing on the merits of the case. There's no proof that it caused the jury confusion or that it influenced the jury to rule against the defendant. Defense counsel, according to the trial judge, she made a statement that there was an off-the-record discussion, refused a curative instruction. He was trying to have it both ways. They requested a mistrial later on in the trial.
Didn't they request a mistrial the next morning, or am I incorrect?
Yeah, it was later. It came out later. And the judge pointed out to him, when I asked you for a mistrial, you said you didn't want it. For a curative instruction, you said you didn't want it. And the trial counsel didn't deny it.
All right. I'm going to have to stop you here because we're way over time. We have your briefs. We will look at all the other issues. Thank you very much, Mr. Torto. Mr. Buckley, you have 2 minutes if you want to address the amounts or anything else.
Yes, Your Honor. As far as the damages go, I would ask the court to look at the Zapata case that's in my brief, where the plaintiff received $400,000 when she was in a collapse of a deck, and she had damage to her femur, damage to her hip, damage to her knee. She's airlifted to surgery in a hospital where she ends up with staples up and down her leg. She gets $400,000. All right. Also, the Singh case, we have a 14-year-old plaintiff there who's going to be living a lot longer than the plaintiff in this case. He's in a skiing accident. He has multiple surgeries and he has injuries to his shoulders. As far as the cases that plaintiff pointed out, the Lopez case, where someone got $1.5 million for damage to the femur, but that person also is a child. He has lacerations to his face, which are not present in this case. And he also has psychological injuries from the fact that his baby brother was killed in the same accident. He's getting $1.2 million less than plaintiff here. The Ramos case is also similar in that there's damages to the tibia and the femur, and the person's getting $2.5 million, which is still not as much as plaintiff is getting here.
All right, well, we will look. Does anyone have any other questions on any other issue? I don't want to preclude that. All right, well, I think we had a lot of questions, so thank you both very, very much. We will take another look at this record.
Thank you, Your Honor. Sure.
Appreciate your arguments today. Bye-bye.
Bye-bye.
And last but not least, of course, Nestenberg versus Standard International. Good afternoon. You may begin.
Good afternoon. May it please the court. Corinne Scotti for the appellant, JES Plumbing and Heating Corporation. It is our position that the lower court erred in its denial of JES's motion for summary judgment. Contrary to the lower court's conclusion that JES merely pointed to gaps in Pavrini's proof, JES presented evidence that it was the mere installer of the sink at issue more than five.
Yeah, but they were the mere installer, but the whole case is about the sink falling off the wall. So I think the installer is kind of pretty crucial in this. He was leaning, the testimony was, and I don't know if anybody testified differently, because there was only probably one other person in the room, that he was leaning against the sink. He was only 187 pounds and it fell off the wall and he fell down and injured himself. So why would the installer not be, qualifying it as the mere installer seems like maybe not right for this case, but go ahead.
I understand that in addition to the fact that they just installed the sink 5 years prior to the accident, they installed many sinks throughout the hotel. They were installed pursuant to the plans and specifications that were provided to them. After installation, they were inspected and approved by Pavrini. And following their installation, they were in the exclusive custody and control of the Standard Hotel. During that time, the sinks were inspected and maintained by the hotel. They were cleaned by hotel staff on a daily basis. They were used by other hotel guests throughout that 5-year period. And during that entire 5-year period, there was never any indication that there was anything insufficient about the installation of the sinks. There were never any complaints, and JES was never contacted regarding any issues with their installation of those sinks. Given all of that evidence, it's clear that JES did not launch a force or instrument of harm in its correct installation of that sink. After establishing that fact, the burden then shifted to Pavrini to raise an issue of fact. And to that point, the lower court was correct when they concluded that although Pavrini asserted that the plaintiff's accident clearly arose out of JES's work under the contract, it failed to submit any proof to support that claim. And for that same reason, Pavrini's claims under contractual indemnification similarly fail in this case.
Well, I thought that the experts stated that you shouldn't, a sink should be able to bear the weight of at least 250 pounds. And since the plaintiff was 187, 183 pounds, less than 250, that the sink should not have fallen. So why would that not be enough to defeat the motion for summary judgment?
Well, to that point, the expert inspected the room at the hotel after this incident happened, many years after, and the sink that they observed was not the subject sink in this case. And to that end, the plaintiff actually testified that when he was shown a picture of the sink that was currently in room 515 of the hotel, that it was similar to the sink that he observed on the day of his accident, not the same sink. So
well, it wasn't the same sink, no offense, because it fell and it broke. So, I mean, they can't put that sink back up. I mean, right. And they may not have had the identical sink. You know, it's hard when you go back after an accident. Things can't always be 100% the way they were before the accident.
I understand, but there was also no other identifying information showing how similar or not similar this sink was. And the affidavit of the expert merely states that a sink of this type is completely unspecific, that if it were to crack or fail, it was either improperly installed or defective.
Well, I thought that the expert said, maybe I read it somewhere else, but I thought it was the expert's report where he said that it was one of, that he noticed that it was, because
The affidavit's on page 919 of the record.
yeah, I made my notes. I can't. The anchor bolts. That's what he said. I thought it was the maybe it was a field supervisor for JES may have been the one that said he was shown pictures and he said one of the anchor bolts appeared to have snapped off and the other one was bent, and that's why the sink fell off. So I mean, there's testimony from your field supervisor that there was something the matter with the anchor bolts of the sink.
But any parts of that sink were given and installed pursuant to the plans and specifications that were provided to JES. And again, the expert affidavit that was given did not mention anything about bolts or what was used to secure the sink in this case.
Well, this is a wall-mounted sink. This is not a sink that's on supports. It's a wall-mounted sink, and it has to have a certain amount of weight that it can sustain, according to the building code too. I mean, you just can't slap a sink up and leave it there.
The other thing I would point to is that the code referenced by the expert referred to static loads. And in this case, there was testimony that the plaintiff was intoxicated and was leaning on the sink for an unspecified amount of time.
The static load here referred to is on top of the sink. That the static load that the sink is supposed to hold is at 250 pounds on top of it. There's no testimony anywhere that the plaintiff was on top of the sink. He was leaning against the sink. That's a much lower static load.
And I would again just point to that this expert did not examine the sink that was the subject of this accident or even a sink that was the same make, model, and type that was involved in this accident. He merely observed a wall-mounted sink and made this very general conclusion.
I thought he looked at sinks. I thought he looked at similar sinks in the that sinks of the type installed in this room. I think it was 515 or something like that.
Correct, but the sink that he looked at that was installed in that room was not the sink that was subject of this accident, and there's no testimony or proof that it was even the same make, model, or type that was the subject of this accident. He merely
he said a similar type sink.
Of the type he observed in room 515 in 2019.
Right. So as Justice Kapnick stated, he couldn't observe that particular sink because it broke.
Right, but also there's no testimony that he observed any of the sinks that were in fact installed by JES in 2009.
Oh,
I believe that's an important distinction.
You'll have a minute or so for a rebuttal. Can I hear from counsel for the respondent, please?
Yeah. May it please the court, Laurel Wettinger on behalf of Pavarini McGovern. Can you hear me? I feel like,
yep.
Okay, just want to make sure. So as you know, and from a review of the order, Pavarini was found not negligent with regards to plaintiff's accident. Every cause of action was dismissed against Pavarini. Pavarini only remains in this case because the court found that there was an issue of fact as to whether plaintiff's injuries were caused by work performed by JES, which would make Pavarini responsible under its contractual indemnification contract with the owner of the property. So at this point, we are only in this case because the lower court found that the contract language with the hotel could apply to make Pavarini liable based on work performed by JES. So, and we believe that we met our burden of proof in this matter by submitting the evidence that there was at least an issue of fact as to the installation of the sink, which admittedly by JES, which was not only supported by the affidavit of Mr. Hannon, was also supported by the other testimony in this case, as well as the contract language, which is completely ignored by JES, which had many responsibilities for JES to make sure they complied with the New York City Building Code, that they installed it properly. And the testimony of Mr. Rosciano of JES, who testified there was also obligations with regards to testing the installation of the sink, and he did not do that. They didn't do it. They didn't test it. They shook it a little bit in the front maybe, but they never tested the wall mounts. So that we believe that the record is sufficient to create this issue of fact with regards to the installation of the sink by JES. And the other point that we brought up was based on the fact that we're found not negligent, and we have a contract with JES, and apparently was overlooked by the court that we didn't have to show that it arose from the work of the JES. We only had to show that it was alleged that it arose from JES's work in our contract with JES, such that we should have indemnification in our favor with regards to this incident. So that's essentially my argument. I know it's end of the day. I won't belabor my points.
Well, thank you for getting right to the point. Anyone have a question? All right, thank you very much. Ms. Scotty, you have a minute or so, and if you want to have any rebuttal.
I will try and be brief in that so everyone can go home. Just one point to the contract. Within our contract with Pavarini, I do think it's important to note that there was a warranty clause regarding the installation of the sinks, in which Pavarini had 1 year to inspect and inform JES of any alleged defects in the sink or the installation. And there was never any such notification or allegation that anything was wrong with the installation or that there was any defect. I would also, again, just point out that over the course of the 5 years from when JES completed the installation to when this accident happened, these sinks were used by many hotel residents. They were maintained by the hotel. They were inspected and cleaned by hotel staff on a regular basis, to the point where if the sink had become loose for some reason, they would have been able to contact JES or possibly repair those sinks. We have no idea if there were repairs or maintenance done to those sinks between the time JES completed their work in 2009, and when this accident happened in 2014.
Haven't you done any discovery on that issue?
Yes, and the witness that was provided by the Standard Hotel had only begun working at the hotel after this accident occurred, but he did testify that in a search of the records, there was no indication that they had ever made any complaints to JES regarding any issues with the subject sink.
Any other questions? All right, well, counselors, thank you very much for the argument. Have a nice afternoon. This now concludes oral arguments for the day, and the court is now adjourned. Good afternoon, everybody.
Thank you.